Good morning. It's Thursday, guys, and court is open. We missed the shackle shuffle. My bad, y'all. We'll see what's going on. I was busy publishing some shorts, so my bad. Um, Good morning, all of Bougie gang. Good morning. If you're new here, welcome, welcome, welcome. We are in court right now. We are in the middle of the Florida versus Sarah Boone situation, and it's live in Orange County, Florida, where Sarah Boone is being held to account for her misdeeds with her boyfriend by the name of George Torres. And the state has rested their case. The defense is trying to figure it all out. We see the defense lawyer, Mr. Owens, there sitting as if he were praying for just a moment, trying to find the magic words to help his defendant because he is going to need them. Okay. Let me make a minor adjustment. This is day 5 of testimony, and we've been in court now for just about 2 weeks, for real, like in earnest, right? Um, it took about a week, took about 4 days to seat the jury in total. And Friday, we opened up with the first day of testimony. So today is day number 5. And it's possible the defense will rest today and the prosecution will start their rebuttal. The prosecution has promised about 2 hours of, I'm going to just say TT. They said 2 hours of video, text messages, and emails. This is going to be the type of day that I think Bougie Gang is going to really enjoy. Full of receipts, full of video, full of what? Okay. Good morning, everybody. How's everybody doing? Good morning, good morning, good morning. How's everybody doing? I'm not gonna lie, I'm gonna be happy to put this behind us because it's on to the next case. Okay. Next case. All right. But at the end of the day, we want George Torres and the Torres family, the children, mom and dad who are still surviving, their son, the brothers and the sisters. We want the Torres family to get justice. I did post in Patreon some documents. Give me a minute. I will post them on a link for you guys to hit it in my PDF thing. I forget what's called, PDF filler, PDF something. I have an app, and I can give you guys a free link. I just need to put all 5 pages together, so you guys can get the links so you can view George's arrest documents. If you have my Patreon, then it's already there. I posted everything together. So there's that. If you guys want to read, I think there's 4 arrests that George may have had more, but as it pertains to Sarah Boone, I found 4. I also posted the arrest document when Sarah was arrested, as a strangler bay. Okay. But there's also the situation mirroring that event because she was using her hands in an inappropriate place and George kicked and she got popped in the eye. So they both got arrested that night, but she had the felony. He had dating violence or something like that. That's um, the restraining order, or I forget what they call it in Florida. They call it a basically a restraining order, a TPO, um, that he should stay away from the home. But again, we know that these two were tumultuous. It was a toxic romance. It was, it was giving hot. They were very much, they were, it was muy caliente. It was very hot, very heated, very tumultuous, very much, happy on Sunday, fighting on Tuesday type thing. Lots of calls to the police, um, all of those things. So not, you know, uh, a good situation. Anyway, I posted all that. So give me some time. I'll post those if you guys want to do your, your own due diligence and kind of read about some of the situation. We've heard about some of it. I think we're going to hear a lot about it today. My mic sounds muffled. Is it this? Are you hearing that noise? Is that better? It might be because there's some white noise coming from the courtroom. Did that make a difference, Cash? Was it the shh type sound? My prediction 2 days from okay, that's the noise coming from the courtroom. Just remind me if I'm not paying attention because I'm looking at you guys, the screen right now. Clicking on you guys' comments, and then if I, you know what I mean? So it's two different screens I have going, so just bear with me. Good morning, everybody. Good morning, good morning, good morning. I wanted to give like a brief synopsis, so hopefully I did it justice, at least for what to expect today. I've been doing a few clips here and there of maybe sort of towards the end of each day and maybe right before lunch of some of like, okay, what did we just learn? Yesterday, can we talk real quick before court comes in? Yesterday, we did not talk about it. Sarah had how many bakers? Was it 2 or was it 3? I couldn't remember. I got to find the clip of that. Baby. So the police called a Baker Act on her on 2 to 3 occasions where they thought that she was unfit to make her own decisions, and she was remanded to the custody so that they could make a decision about, was she okay? Was she competent to take care of herself? Is she mentally sound? All of these things. Okay, so they're checking in.
Good morning, ma'am. Can you state your name and date of birth for the record?
Okay, we'll talk.
Sarah Boone, 10-10-7-7.
Ms. Boone is seated at counsel's table, buttressed by her attorneys, wearing a black suit and pink blouse.
So it's 2. That's enough.
All members of our jury
Most of us will never even have one.
This morning.
She said 2.
Is there anything we need to address before we bring in our panel? Defense, anything we need to address?
Yes, Judge, I intend to introduce.
Hey, Vicky. Good morning, boo-boo.
And situated to. One is,
Girl, Dr. Julie was a mess.
Right now, your ID is AD as in boy and AC as in.
Yeah, the sound situation.
June 16th, 2019, it's a no contact order.
Okay, so non-contact order. No contact order.
AC. And it is a no contact order.
Let me tell you something, at least what I've heard.
Into evidence, and then I'd like to hand publish them to the jury.
Okay.
And let them look at them one at a time. And then I believe.
I'll have to look it up and just make sure I know what I'm talking about here. Hold on.
I guess you would excuse the jury because Sarah Boone needs to be questioned about.
And there may be additional motions to be addressed at that time. So yes.
Do you want to do that now before we're ready to adjourn?
I don't have a problem with that. If you want to rest now, subject to those being entered and published, and we can address any motions. The court has reviewed both of the no contact orders. And that way we don't have to do a in and out. And I can colloquy Ms. Boone at that point in time, and we can proceed with the state's rebuttal case.
Subject to those, the introduction of those 2 exhibits just mentioned, the defense would be resting our case at that juncture.
Okay, all right. Yes, ma'am.
Sometimes no contact orders work both ways.
I've been advised by the courtroom deputy that the juror wearing badge 130, seat 10, cannot stay past 5:30 today. So just be advised, we'll use our time accordingly.
That was the 6th.
I don't believe so. Give me a moment, I can check.
So I don't know if it was a no contact order issued both ways or Sarah and George were both restricted
is an
from
alternate. It's
reaching out
alternate
to each
C4.
other?
Thank you.
Or was it just, I would imagine if you don't want the person to contact you, you should not be contacting them. I can't say it's null and void because Sarah
Defense, do you have any
chose to
motions?
open the door for him, but girl, Florida statute 74.1.30 outlines the parameters of the process of domestic violence injunctions. No contact order is a court order. Person who is requesting a court order, no contact order, the petition will have the file through the clerk of courts.
I don't have any additional arguments other than what was made the other day.
Okay, thank you. Any other additional argument, Mr. J?
Just that at this point in time, the standard is whether or not a reasonable trier of fact could find the defendant guilty, and there is sufficient evidence for that to be sent to the jury.
Thank you. The court recalls the arguments that were made after the conclusion of the state's case, both from the state and the defense. The court finds that a reasonable juror could make a finding of guilt on the elements of the sole charge and the information beyond and to the exclusion of each and every reasonable doubt. For those reasons, the renewed judgment of acquittal is denied. Ms. Boone, I have a couple of questions to go over with you, ma'am.
Okay, Beck tried it, but you know, they do that. They're just doing their job, asking for an acquittal, and Mr. J promptly stood up and said, not today, that we have provided sufficient evidence and argument to continue the case forward, and the judge agreed and denied. So, okay, let's keep going. He's going to
You've been previously sworn this morning.
colloquy. Ms.
Your attorney
Boone.
has indicated that all of the evidence and testimony of all witnesses in your case have been presented to the jury, with the exception of the two no contact orders pre-marked as AB from June 16, 2019, and the no contact order of June 19th,
That was like
2019, pre-marked
6
as
weeks
AC,
ago. She
which
got
once the jury comes
an
back
attorney
in,
came
he
out the
will enter into
bushes.
evidence and
Anyone who's new here or kind of a little behind, I would encourage you hit the Sarah Boone playlist. Everything is there. But that was like 45 days ago. She got someone stepped up. His name is James Owens and company, and them folk came from another part of Florida to come help sis out. So jump back in the playlist when he made his first appearance, but she has representation. And that's been going on for about a little bit over a month and a half now.
and produce them to the jury for their viewing. Are there any witnesses that you wanted to call that your attorney failed to call?
No.
Is there any evidence that you wanted your attorney to present that any of them failed to present?
I'm reading something on that now.
Are you satisfied with all of your attorneys up and until this point?
I would think so, but we have to see.
Is there anything that you would like to
She
bring to my
got very
attention at this
lucky,
time?
Brick City.
No, Your Honor.
Okay,
Good
all
morning,
right.
good morning, good morning to everybody
I
in the
did
house.
receive
Good morning, good morning,
the
good morning.
proposed jury instructions this morning. I'll look at them during the lunch hour, and after the state concludes their rebuttal case, we can proceed with addressing those. Mr. Beck, yes, sir.
No, the defense did not receive the red line copies that the court discussed yesterday. I don't know if those were sent.
I emailed Ms. Barrios last night. Once we got out of court, I'll send them to everyone this morning. Just give me a moment and I'll get those out right now.
Y'all, we don't care about typos over here. We're not fussy like that. Girl. It's okay. No need to apologize for typos. We know hooked on phonics. We can read even when it's spelled wrong.
Is there
It's
anyone else?
2024.
The email
okay?
correspondence that I have is Mr. Owens' email.
Don't apologize for that.
Ms. Andrews' email, Mr. Cacciatore's email. Is there anyone else that may need to be sent to from the defense side?
We'll pass them around.
Okay, all right, very good.
Okay, unless they're going to talk about anything else, I think I'm going to get us caught up because we're like about a minute behind. So, okay. All of the pleasantries. Do you recognize the jury? Do you recognize the jury? Good morning. Do you recognize the jury? Did you guys follow the directions last night? Were you guys doing research? Were you on the internet? Did you tune into RealTalk Bougie? Okay, let's keep going. Okay, good morning. Okay, we're caught up, y'all. Good morning, good morning, good morning to everyone. If you're new here, subscribe, hit the notification so you won't miss a thing. Okay. Is that Brick City? Is there
State, you
any
recognize
other
our
Brick
jury.
City?
Yes, Your Honor.
Defense, you recognize our jury.
Yes, I do.
All right, thank you. Y'all can be seated. Good morning, members of the jury. Welcome back to 12
Sarah's
Alpha
voice
in
is
the Orange County
irritating.
Courthouse. If you could, just raise your hands to confirm that you complied with the court's instructions last night during the break. I thank you. Record will reflect that all jurors have raised their hands. We're going to have a little bit of additional evidence presented by the defense this morning, and then we'll go from there. Okay? All right. Thank you very much. Mr. Owens, you may proceed, sir.
He is so annoying. I feel like he went to the Matlock School of Law. I feel like he tries to be Matlock.
Identification exhibit AB and evidence.
No objection to AB or AC.
What was pre-marked as defense AB will be received into evidence without objection as defense 19. And if you could just identify AC for the record, sir.
But at this time, I would like to move defense identification AC into evidence.
Hearing no objection from the state, what was pre-marked as defense AC will be received into evidence without objection as defense 20.
And Judge, I would like to publish these to the jury and allow them to take their time and pass these down to.
You may proceed.
The first is defense exhibit 19, which just review it and pass it down.
It would be so nice if the defense, which this thing is almost over, but it would be so damn nice if they could get to court on time and sort through their papers and have them published. Because Miss Clerk of Court is sitting there probably 8:30, 8:15, ready to go. And I'm sure Mr. J was in the house to get things published. And could have been doing that while he was sitting there looking like he was in prayer 20 minutes ago. Why didn't you do that then? To me, it's like not respectful of the jurors' time and the state's, the whole entire state of Florida that's paying for this time, and your colleagues who appear to be sitting there for free. Allegedly sitting there for free. And Sarah, stop writing. It's like she's writing her memoir. She's writing a journal. Dear Diary, is this actually happening to me, or has this been a long dream? I feel like I'm still in my apartment, and I'm waiting for George to come home with a bottle of wine. Please wake me up from this nightmare. Love, Sarah. It's very unprofessional and disrespectful. Absolutely. She's not taking notes. She's writing in her journal. Dear God, it's me, Sarah. Please send the magic words for Mr. Owens and Mr. Henderson and Mr. Beck to put a spell on the people of the jury so that I can be free. Amen. She's painting. She's actually doing a jail puzzle. Yes. She's creating a puzzle in how to unfuck yourself. This is the how to unfuck myself puzzle, created by Sarah Boone on the fly, day 5 of testimony on 12 Alpha. That is the 12th floor, A courtroom. This is the 12 Alpha Sarah Boone day 5 testimony puzzler. How to unfuck myself. And by Thursday, your girl gets very silly. Okay, of course, I tuned into Real Talk Bougie. Okay, duh. Okay. I had another friend from the bushes. They're riding around town somewhere, hopefully not getting into any kind of shenanigans, listening to this broadcast. Be safe out here on these streets listening to this, okay? But I thank you so much. I thank you guys. You guys are so awesome. Y'all, your girl, after I got off live last night, since they were taking their time, I'll just tell you guys, y'all, I was over there at the football game. I had to go to a school football game. Your girl knocked it out the box with concessions last night. We sold over $500 in concessions at the football game, and our team won, of course. Okay. All right. After I finished with you guys, I got on my mom stuff and I got on my volunteer for my daughter's school. And we handled that business at the football game last night. Even though my daughter does not play football, your girl still volunteers. And our team won, and we collected mucho dinero for the athletic department. Okay, thank you. And bought home some Chick-fil-A for my husband. Okay. Yes, it was our last game of the season.
Mr. Owens, any other additional witnesses, evidence, or testimony, sir?
No, sir, on behalf of Sarah Boone, the defense rep.
Thank you.
Thank you,
Defense or
Jesus.
state, are you intending on putting on a rebuttal case?
Yes, Your Honor.
You may proceed, sir.
Speak with Dr. Tanya Warner.
Okay, so guys, if you did not notice, the defense, and I'm going to just, this commentary too, and the lack thereof, defense has rested and the prosecution is in the process of doing their rebuttal case. This is not common in every state. Every state doesn't do rebuttal cases, but Florida, you get an opportunity to kind of revisit and present additional evidence. So they're putting on their rebuttal case, and this is what we're saying. Okay, come through black suit, white piping. Okay.
We swear or affirm the testimony you should give shall be the
And
truth,
bun.
the whole truth, and nothing but the truth, so help you God. I do.
Doctor, good morning. Could you state and spell your name for the record for us?
My name is Tonya, T-O-N-I-A, Warner, W-E-R-N-E-R.
All right, thank you. You may be seated, ma'am.
Thank you.
Good morning, ma'am.
Good morning.
Where do you work?
I'm employed at Meridian Behavioral Health Care in Gainesville, Florida.
And what services do you render there?
I'm their chief medical officer.
Okay,
And
Chief.
can you tell the jury what your educational background is?
Yes. So I graduated with an undergraduate degree at the University of South Florida in chemistry. I then attended medical school at American University of the Caribbean. I did a residency in psychiatry at Connecticut Valley Hospital in Connecticut under the auspices of Yale University. I then came back to Florida and did a fellowship 1 year in forensic psychiatry at the University of Florida.
And since your educational background, what have you been doing professionally?
Yes. So I'm a licensed physician in Florida. I am board certified in general psychiatry and forensic psychiatry. I was initially employed on faculty at the University of Florida from 1998 through 2015. I retired there as the vice chairman of the Department of Psychiatry and the director of the Forensic Institute. I then went to work as the chief medical officer at Meridian Behavioral Health Care, which is a community mental health center.
What is psychiatry?
So psychiatry is the treatment of mental health disorders.
And what is forensic psychiatry?
Forensic psychiatry is the interplay of psychiatry and the law. So anywhere where psychiatry intersects with legal issues.
What is the difference, if any, between a psychiatrist and a psychologist?
So a psychiatrist has gone to medical school, where a psychologist has not.
And as a licensed physician, are you able to prescribe medication?
Yes, I am.
In the course of practicing medicine as a psychiatrist, do psychiatrists prescribe medication to treat mental disorders?
Yes, we do.
And when did you begin your work as a forensic psychiatrist as opposed to working at the faculty at the University of Florida, or was that concurrent?
In 1996 in the state of Connecticut. While I was doing my training at Yale University, I testified for the first time as an expert witness in the state of Connecticut.
And over the course of your career, have you done forensic psychiatric evaluations?
I have,
Approximately how many?
thousands of times.
And does this include on matters such as competence?
Yes, it does.
And does it, just explain briefly to the jury, what does that mean, legal competence?
So competence is, do they understand the legal process? Do they understand who the different players are in the courtroom, who's on their side, who's not on their side, what they're charged with, what the possible penalties are, what the possible plea options are?
And have you ever done any forensic evaluations about insanity?
I have. I've done sanity at the time of the crime, and also I've been appointed by the governor of the state of Florida to do sanity for execution.
And have you ever been involved in working as a forensic psychiatrist involving the subject matter of battered spouse syndrome?
I have.
Can you describe your experience in that area for the jury?
I've been asked to do evaluations by the prosecution and defense several times with regards to, and it's come up in different cases, criminal cases with regards to intimate partner violence.
And does all violent episodes within a relationship result in something that we are describing as battered spouse syndrome?
No.
And I see there is a book in front of you. What book is in front of you?
Yes. So this is the Diagnostic Statistical Manual, and this is the 5th edition text revision, which is the most current edition.
Is battered spouse syndrome in there as a diagnosis?
No, it is not.
And where, if anywhere, does it fit into any of the categories within the DSM-5 TR?
It would come under one of the trauma categories, most specifically under most likely post-traumatic stress disorder.
Can you describe for the jury what post-traumatic stress disorder is?
So this is a disorder that's recognized under the DSM for individuals who have suffered a traumatic event, and then they have re-experiencing of the traumatic event. They have different symptoms besides re-experiencing, such as hyperarousal, and also avoidance of triggers or symptoms, things that would trigger a response to it.
Are there any agreed upon criteria within the relevant forensic psychiatric and forensic psychological communities about battered spouse syndrome?
There are.
And what would those be?
So it's again, having experienced a trauma, repeatedly, violence within an intimate relationship, and then having symptoms secondary to that, avoidance, so tiptoeing around, trying to avoid recreating the violence.
And if a person experiences an environmental stimuli. Something happens to them, another person does or says something to them. Is their subjective reaction what is defined as whether there's trauma present or not?
I'm not sure I understand the question.
Let me rephrase it.
You can rephrase.
Calls.
You described there's a difference between experiencing a violent relationship and whether or not that person is going to experience trauma from those behaviors they witness and experience. Is that fair?
Yes.
Now I've lost my train of thought. Is it fair to say that an experience that a person has, whether or not that person believes it's traumatic, is a subjective experience?
Yes, each individual is different, and so each individual is going to take that experience differently.
Can hypothetically a couple be involved in a violent relationship for a number of years, even 3.5 years, and battered spouse syndrome not necessarily apply to either or both of them?
Yes, that's correct.
Can you explain that?
So again, each individual is different. So one individual may develop the symptoms of battered spouse syndrome, and one individual may not under the same exact circumstances, just depending on their makeup and what they've experienced in their background and their biological makeup.
And is there a cycle of violence that is sometimes used to describe battered spouse syndrome?
There is.
Can you describe that?
There is. So there's the initial, there's kind of a tension buildup section where you feel the kind of tension building up, and the individual can feel kind of the incident coming, and then there's the actual incident of violence. And then following the incident of violence, there's a honeymoon phase, what they call the honeymoon phase. And that's the third phase where the individual who created the violence attempts to make up to the victim and recreate kind of the relationship and pull them back in. And then it starts all over again where you feel the kind of tension start building up again to the incidents of violence.
Does abuse have to come in the form of physical or sexual violence?
No.
Can you explain your answer?
So it can also come in ways of coercion. It can come in ways of control, such as financial. So if an individual controls another individual financially, or controls their ability to drive or go out, their ability to be around their other family members or friends, kind of isolates them from other individuals, controls their ability to work, so controls their ability to make money or access the funds, so they can control them in any number of ways.
Is this kind of about like an inequitable power dynamic in the relationship?
Yes, absolutely.
Can a man be on the receiving end of emotional or physical or sexual trauma and potentially experience, strike that. Can a man be on the receiving end of verbal, harsh words, physical violence, or sexual violence and end up having the syndrome of battered spouse syndrome?
Yes, it crosses all boundaries, and we see it in all types of relationships, whether it be heterosexual or homosexual relationships. We see it cross all boundaries.
And can this element of control come from controlling personal items such as identification papers?
Yes, absolutely.
Can control potentially, hypothetically, come from partner A gifting partner B an item, but still considering that item partner A's because he or she paid for it, even though it was a gift?
Yes.
And in this particular case, were you asked to do an evaluation of Sarah Boone?
Yes,
Do you see Ms. Boone in the courtroom today?
I do.
Can you point out where she is and what she's wearing?
She's sitting at a table there wearing a dark suit and a pinkish top.
May the record reflect she's identified the defendant.
Record will so reflect.
What date did you have an evaluation of Ms. Boone?
It was early in October, I believe October 2nd.
And this was at the request of the state of Florida?
Yes, it was.
and subject to a court order?
Yes.
And who was present for this evaluation?
The defense and the prosecution.
All right. Tell us about the evaluation with Ms. Boone. What do you do first?
So I met with Ms. Boone at the jail in a conference room. Again, the prosecution was there and her attorney. I met with her for approximately 2.5 hours, just under 2.5 hours. I introduced myself and explained that the interview would not be confidential, that I would be coming to court if asked to share my opinions. And she agreed to participate. I then start out with just general information, so getting to know her, date of birth, kind of background information, who her parents are, childhood. I go through her educational background, work background, her marital background. I go through health, psychiatric background, any substance use issues. I do a mental status examination.
Can I stop you there?
Yeah.
Elaborate further on that.
So a mental status examination is just questions to determine kind of memory and cognition, kind of how their thought process is, how they're thinking. Are they able to kind of fluidly think through processes?
All right, go on after that.
And then I transitioned from there into walking through the incident that happened with her.
All right, what did she indicate occurred on February 23rd, 2020 to you?
All right, is it all right if I refer to my notes just to?
Just if you need them to refresh your memory, please do so, but don't read from them. Just let us know.
So she had a difficult time recalling what time they actually woke up that day. Initially, she said in the morning, and then she said she wasn't even sure that it was in the morning. She said that they both wanted to drink, but that she asked that they could clean the house first instead, and that they did some vacuuming and cleaning. They had a half a bottle of wine left over from the day before that they drank. She felt about 4:00 in the afternoon. They drank that out on the back porch. And she described that they had kind of 2 beach chairs out there and a dartboard, and that they kind of hung out there a lot on the back porch, spent time out there. They did a puzzle out there. And completed that, and then did some kind of artwork. She felt like he was getting frustrated thinking about his life, that he had lost his job. And so she encouraged him to call his daughters, although she knew that that they did not like to talk to him when he was drinking. So I'm not sure why she had encouraged him to call them at that point, because they were already drinking. And she also at some point encouraged him to call his brother, because she wanted him to explain to his brother that he had pulled her down the stairs the night before, although that didn't happen. He didn't explain that to the brother, and according to her. And then at some point they went and got another bottle of wine and some cigarettes from the grocery store and continued to drink. And then they were inside the house, and then he, I guess, tagged her at some point and said, "Tag, you're it," which indicated that they were going to play hide and seek. And she said she went upstairs and hid in the shower and waited for him to come, and he never came upstairs. Excuse me. And so she eventually came out of the shower to look for him. And as she was coming down the stairs, she said she saw him slipping into a suitcase, which was on the living room floor, that they had put out because they were going to donate it. And sorry. And so she went downstairs and indicated that she had found him, and they were kind of laughing, and she zipped the suitcase up, and they continued to laugh, she said, at that point. And they were having a good time and laughing and enjoying themselves and having a good time. And she said, and then she became angry. And she said she remembered what it felt like when he was choking her, and she became angry.
What did she do after she became angry?
I'm going to refer to my notes at this point.
If you refresh your memory, just
Yes.
put them down and then tell us what you remember.
She said that she shook the suitcase and that she lost control of it and it flipped.
And then what happened?
Then she said that he stuck 2 fingers out and her son's baseball bat was sitting there and she picked the bat up and hit his hand.
Then what happened?
And then she went upstairs and waited for him to come upstairs.
All right. Alcohol. Can you tell us what you know about the effects as a medical doctor of ethanol or alcohol on the human body?
Yes. So it causes intoxication, as we all know, and it causes disinhibition. It works on the frontal lobe of the brain and allows us to do things that we wouldn't normally do. It disinhibits us.
And in the course of your practice, have you ever come across a diagnosis of alcohol abuse disorder?
Yes.
And what is that?
Well, alcohol abuse is an old disorder. So we used to use alcohol dependence and alcohol abuse. It's now been combined in the DSM-5 and the DSM-5 TR. It's alcohol use disorder.
In considering what a patient or a client or somebody that you've been asked to evaluate by a government entity, do you take into account that person who's relaying the history to use a consumption of alcohol at the time of the history that they're given?
Yes.
Why is that?
Because again, it affects their behavior and their actions.
Does alcohol have any effect on a person's memory?
It can.
What, if any, relationship is there between acute alcohol use or acute alcohol intoxication and battered spouse syndrome?
It can affect your memory. It can affect your reactions. It can affect your response to different things.
Does the disinhibitory nature of alcohol strengthen, weaken, or have no effect on battered spouse syndrome?
It would depend on each individual again.
Generally speaking, it is important as an evaluator to get as much information as possible before rendering an opinion, such as diagnosing somebody with something out of the DSM-5 TR or battered spouse syndrome.
Yes.
In this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening?
I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change.
And what was your opinion?
My opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
And specifically talking about it.
People could work Spanish.
Yes.
I think they are hinging on this PTSD because people with PTSD are, I think, a sign or maybe a byproduct of PTSD is like the snap, or blank or flipped out or blackout type. Not that that's indicative of everybody with PTSD, but I think if someone has PTSD, if they snap, then I think they want that diagnosis to stick, and because I think they want that to stick because if she's got PTSD, then they could use that for the trigger of something that seems as a call for help. Well, because she's got a certain mindset due to her trauma, she took that, she misread the trigger and decided to go ahead and let George die in a suitcase. I'm just, I mean, that's just my opinion. I don't know that that's the case, but I think that that would be, oh, look at that. Thank you. Yes, absolutely. This all applies to move on all these things many years ago, ironically, but I don't see the one-sided dynamic here. I like that she said that she didn't have enough information. Yeah, for PTSD, but she has several diagnoses previously, and they are byproducts of her previous trauma and her life prior to meeting George. They're not necessarily indicative of PTSD. And PTSD isn't like, PTSD could be something that someone could suffer for their whole entire life. Maybe some people they are able to deal with their PTSD. Everybody is not triggered by PTSD. Through therapy, people learn how to deal with it and to not be triggered. But I think they really want to try to make this PTSD be a catalyst for her misreading a cue, calling it a cue for help, calling it a trigger of aggression, and trying to use that. But honestly, like I said, in my heart, I still fall back on the sensibilities of normal folk who are not hypersensitive to any little, you know what I mean? I think they did I'm hoping they did a good job to pick the jury of people who are not going to be triggered by this story in a way that they're going to be like, oh my God, yeah, she did the right thing. Like, yeah, they blinked and I ran, you know what I mean? And I knew I had to shelter, or I knew I need to go grab all of the people who knee jerk react. I think that it's, the unreasonable kind of like, I hate to keep bringing up Susan Lawrence, but that was the last case that we watched over here, I think. Susan Lawrence was afraid of her neighbor across the street. She engaged in some loose talking and told the boys, tell your mom to come see me. Mom came over and ma'am shot through a locked door and thought that was okay, and killed the mother of 4 children. And she's gone to the penitentiary. She'll be sentenced very soon. So those knee-jerk reactions of I know what someone's going to do before they do it is not acceptable. So that's the hope. But yeah, I think that I'm sure the jury is can see through all of this, but yeah. Anyway, let's keep going. Sorry for the lags, guys. This is just, I guess they're trying to get the one thing someone pointed out yesterday, like all the sidebars and kind of like, I'm sick of the approach kind of thing, which a lot of you have said that. So let's just talk about the difference between like YSL, or where we see in some courtrooms. I don't want to say YSL specifically, but I know a lot of you guys have been dipping in over there, here and there. The difference between, let's say, Judge Page Whitaker and Judge Cranick, when someone objects, the judge immediately has them come to his closer to the bench and state their arguments, right? And it's very much more, it's giving more professional, right? Not to call out anyone in Fulton County for not being professional. That's not what I mean. But when you're objecting and they're arguing back and forth and they're giving their reasons and this, that, and the other thing, if it's out of earshot and from the jury, then maybe those arguments don't necessarily need to taint their perception or the argument. I don't know. Maybe it's just a different tactic of being a little bit more discreet in the argument to not have the argument and the law interfere with the evidence and the testimony. That's just like, I was thinking about that last night, where you see in some courtrooms when they object, it's very much like argument back and forth. If it goes too much, they'll clear out the courtroom and then bring the jury back, right? This particular method of having a more quiet sidebar leads to less of the jury having to clear the room, and also turning off the microphones because something that they don't want on record, something is really just, I don't know. You guys drop your opinions below, but I think the objection kind of approaching the bench is just a way to keep it a little bit more focused on the arguments and the testimony and actual evidence admitted to the record versus the off the record conversations between the attorneys and the judge, and get a little more salacious and tea, and there's an argument or there's this and that and the third. I don't know. Yes, it's less argumentative, and it keeps it, yeah, because everybody can't hear. I'm sure the judge has his microphone off. Everyone in the gallery can't always hear. So what the judge and the two sides are discussing, right? So, because I was watching some YSL last night. Someone pointed out to me that there was, some drama, and Judge Whitaker is tired. Sis is so through with everybody in that courtroom. It's a mess. It's unprofessional. So it's very unprofessional, and we know Glanville was having a hard time. Whitaker's having a hard time, and it's a shit show, right? Look at the doctor. Come through, pearls. Okay. There's just sometimes when you put on some pearls and people know, and people know, they know what's going on. Girl, those YSL jurors, my Lord. Okay. Yeah, it's more professional, even though we're sitting here waiting and it's like, I wonder what they're talking about. What they're talking about isn't really for our ears and not for the jury either. Not to say the jury can't hear, but they're probably making every effort. There could be noise filtered into the court, so that they do have a hard time hearing, but it's not on the record. So even if you're eavesdropping and hear a little something, something, that's not the case, right? Girl, she's annoyed. She's rolling her eyes. Yeah. Well, they got to get it right. Girl, we want to know because we're nosy, right? But yeah, it's just the difference. You see how...
Members of the jury, thank you so much for your patience. I have a matter I have to discuss with counsel outside of y'all's presence.
Okay, now
It may
we're going
take a little bit more time.
Now we're going to get to
Just
find
our conference
out.
up here. We
Okay.
don't want to have y'all just hanging out waiting for us to figure out what we're going to
Go
do
get a
next.
coffee.
So I appreciate your patience. We're going to excuse you to the deliberation room at this time. Please do not conduct any independent investigation or research as to the person, places, things, or charge involved, and do not have any conversations amongst yourselves or anyone else about those things, and we'll bring you back in as promptly as possible. Thank you.
If you're wondering who the person is behind the judge, if you're new here, the judge participates in mock trials at one of the law schools, and he periodically has some students in his at the bench. Okay, he sometimes has some students sitting with him,
Y'all can be seated.
and these are some of his students that
Mr. Owens, if you
participate in the
can
mock
find me
trials
that portion of the
moderates.
transcript that we were addressing as to additional opinions and other depositions and anything in Dr. Warner's deposition that you believe we need to address regarding this opinion as it relates to PTSD.
Well, and Judge, it applied to every opinion she was going to express. It started on page 37, line 24. As it relates to Sarah Boone, do you have any diagnosis as it relates to her? And then 38 is when she started talking about a generalized anxiety disorder, and that she was not for sure whether Sarah Boone had a generalized anxiety disorder versus if it was just an adjustment disorder to being in jail. And then she also mentioned in that same answer that Sarah Boone had some narcissistic personality traits, and that those were my two major diagnoses. And then I questioned her further about that. She explained again on line 17 about general anxiety disorder versus the adjustment disorder, and that I hadn't had time to fully formulate that opinion out. Line 21, I need time to go through my notes and think about it and process it.
Page. We're still on page 38.
38, line 21. I need time to go through my notes, think about it, process it. But I had the other depositions, as you're aware, yesterday, so I had to prepare for those and go through that. So I have not had time to process all my notes. And I said on line 39, well, doctor, I'm trying not to inconvenience you. You know, we're set for trial October 7th for jury selection. Line 6, I anticipate your testimony would be until a little later. So we could discontinue the deposition and then reset it when you've got time to review. Because obviously I'm not going to want to take your deposition and you have other opinions that are not going to be covered. And then I asked, looks like Mr. J asked, what's your position? He said, conducting discovery after the jury trial starts is completely unacceptable to me. So that's my position. If she needs to issue a supplemental report, or if there has become a need for a second deposition, then we can address that. But it would be my position that we need to get this done because the state doesn't have any appellate rights once jury is sworn and jeopardy attaches. And I say on line 23 of page 39, well, you obviously understand my position. I'd like to finish the deposition today as well. But if she is holding out that she may have other opinions and other diagnoses after she has had more time to think, review the paperwork, then obviously that creates an issue. And then she said, but if that happens, I can bring that forward, and then you can add to your deposition at that point if my opinions change after having reviewed further. And I referred to Mr. J. Page 9 of 40, Mr. J says, I think we plow ahead. This is our time with her. Court reporter's prepared to give us a transcript by the end of the week. Something needs to be amended.
End of the weekend.
End of the weekend. If something needs to be amended, then she can A, issue a report. B, if we need to take a deposition, an abbreviated deposition on the limited subject matter she is not prepared to testify about on today, then we can do that. But the notion of halting a deposition today that is set for 3 hours and then doing a 3-hour deposition during trial, especially after jeopardy is attached, is not what the state would do. Then I respond on page 40, line 23. I'm not suggesting that, Mr. J. I'm suggesting what you just said at the very beginning, which is let's finish. But if she has some supplement, then I would want to take a brief second deposition as it relates to any new diagnosis or opinions. Mr. J responds on line 4. Okay. What I'm understanding her to say is right now, there has been a previous diagnosis of an adjustment disorder in some of the records, and she just needs to review her records to see if she thinks that is the best diagnosis that she would give as opposed to a generalized anxiety disorder. And then the witness says, you essentially flipped that, Mr. J, upside down. You got that backwards. So we go on to page 42. Line one, Mr. Owens, I agree. And Dr. Werner, just let the state attorney know.
Okay, but we're skipping a massive portion of 41
Okay,
that addresses specifically opinions
let me go back.
as it relates to generalized anxiety disorder.
Okay, the witness starts on line 15. So she's saying she has the generalized anxiety disorder, and I'm saying I want to review it more. Because Sarah Boone had disclosed to the doctor that she had been previously diagnosed with a generalized anxiety disorder. And so the Dr. Werner was considering that admission, but she was saying, I want to review it more to see if I think it's more of an adjustment disorder to being in jail, Judge, to being in the correctional setting right now. And that the stressors that she is under right now as opposed to a generalized anxiety disorder. So Mr. J says on line 22, okay, so on this topic, if something new comes up, then we can address it. But if you have other topics to depose her on, then I suggest we go on. And then page 42, line 1, that's when I say, I agree, and Dr. Werner, just let the state attorney know. I know that you may be, we are on short time. If you do review your notes over the weekend or whatnot, and formulate any other opinions, just let the state attorney know, and I will address it.
We'll address it.
And we'll address it. Line 7, the witness, Dr. Werner says absolutely. And then, do you want me to continue reading or?
If there's portions you want to highlight for me, I mean, I have the transcript. I'm following along with you.
That was the general understanding that we had about all diagnoses, all opinions that she may have. And so she starts talking about the mental status exam that she gave her, and then she page 43, line A, she said she has narcissistic personality disorder traits. Or I asked that question, That's how she answered. She goes through a little bit of that. And then paraphrasing, she talks about the grandiose component of criteria that she met. And then on page 45, I asked her what other criteria on line 1 would tend to indicate that she was a narcissist. And the answer by Dr. Werner, I didn't say that she was. I said that she has narcissistic traits. And that was the examples. That was.
Excuse me for interrupting, but can we lasso this back into?
I understand that's what the depo reflects, but the non-objection which led to objection pertains to an opinion specifically about post-traumatic stress disorder. And at this time, no opinion is being referenced, nor does the call of the question pertain to narcissistic personality traits or diagnosis of narcissism. The question pertains to PTSD.
All right, page 46. Line 1, question, okay. Do you feel like she suffers from post-traumatic stress disorder? Line 3, answer. She didn't give me criteria with regards to that. She discussed having fear and anxiety of his family and fear that they would come into the jail or have someone else come into the jail and harm her. She talked about that. And she spoke about, having recollections, remembering abuse from George during the evaluation. Question 13, line 13 on 46. But you don't believe that she suffers from post-traumatic stress disorder, in your opinion? Answer, line 15, no.
Okay, what is he trying to argue? If you recall, right before the doctor was talking, the state attorney, Mr. J, asked a question. Did you diagnose her? If I'm remembering correctly, he asked her something about a diagnosis for PTSD, and Mr. Owens objected. As I stated, Mr. Owens wants that PTSD because the PTSD would probably lead to a snap, a flip, I didn't know what I did, a knee-jerk reaction for beating the shit out of Mr. Torres in the suitcase that she's already locked him in, because on that day she probably decided she was going to kill George. Like, let's just say it on Thursday, okay? I think she decided to trick George into the suitcase, got him in the suitcase, zipped him up, beat the shit out of him, and came up with a story 13 hours later to call the police when she called her husband, ex-husband, 3 times for him to come help her, and he didn't want no parts of it. Okay? So she's trying to come up. Having anxiety disorder doesn't give you enough of an excuse, but PTSD does, because PTSD folk are triggered, right? If you're triggered, then you can do something knee jerk because, oh my God, I've got PTSD, rather than I've got a situational kind of disorder where I pivot because of something that happened due to my trauma. I can pivot quickly, adjust and adapt. So they're trying to hang on to the PTSD because that will give a reason why she flipped and used a absolutely not that she used an absolutely over the top remedy for something that it should not have been. It stands to reason George would be pissed, because if you can't breathe and someone takes you to an inch or two of your life, you're gonna be mad, right? So of course he's getting mad, but he's dying. And she takes the opportunity to beat the suitcase. That's the new story. We didn't know that at first, but then she tells this to all the doctors later that she beat him, okay, while he was in the suitcase. So I think the PTSD gives a little bit more of a reason as to why she used a illogical response, because there's no overt act. Let's get back to the overt act. They need the overt act for the battered wife syndrome, and battered wife syndrome is not a defense in and of itself. Battered wife syndrome is like symptomatic of a it's like a byproduct to the self-defense. So she could say, I was defending myself, but because of the PTSD, she had a warped view of what was actually really happening, and that's why she used a warped defense. Because really and truly, Mr. George was really just trying to get out of the suitcase. Would he have been pissed? Probably, but she also could have fled the scene, right? She could have unzipped it to a certain point. By the time he got himself out, she could have been down the street because she had the keys to the car. She had a vehicle, he did not. All of those things, right? Not to mention he's hot. He's been in a suitcase for 20 minutes. He's not coming after you, right? So that's why there's this argument right now over PTSD versus her generalized anxiety disorder and her narcissistic traits, because of her narcissism probably led her to doing what she did, right? So Mr. Owens, her lawyer, doesn't want that in here. So hopefully, maybe, I mean, I don't know if I did a great job of explaining that, but I think that that's what I'm observing. So hopefully that kind of works that out a little bit more.
I would have to look back through my notes.
And also, let's just throw in a little bit of grasping at straws. These lawyers are trying to do whatever they can to get their client off, and that's their job. So keep in mind, you got to kind of, take everything with a grain of salt on both sides, because it's the prosecution's job to get justice and not to say they're grasping at straws. They've got the burden. They've got the evidence. They got the tea. Mr. Owens is mad, because he's not getting to push the argument or the narrative in the direction that he would like. And, unfortunately, he's got a client that's not a great client because she has been lying, y'all. We talk about the unreliable narrator here all the time. All my channels. We talk about the liars, right? Okay. We talk about the liars. We talk about the people who tell us stories. They tell us their version, their truth, all of the things. But their version, their truth isn't always the truth, right? We have people who tell us what they think we want to hear so we can be on their side, right? That's Sarah Boone.
To see if she fully met the criteria. Question, line 17. Can you explain why you don't think she suffers from post-traumatic stress disorder? Answer, line 19. No, I didn't say one way or the other. I would have to look back through my notes for that. Line 21, question. Is that something that you may, in the future, give an opinion about after some time reflecting and reviewing your notes? Line 24, answer, I may. Number 25, question. Okay, and that's something you will let the lawyers know about if that changes? Answer, line 2 of page 47, yes.
Lambo came up and kissed Portia, and she was just like, no.
That's specific to the post-traumatic stress disorder.
Okay.
So at the time of this deposition, when I asked her specifically,
So what's the legal objection? What are the legal grounds of the objection?
And if you're wondering why Cranick is, I don't want to say he's being accommodating, but he's very patient. Sarah has had, this is her 9th set of lawyers. Okay. This has been going on for 4.5 years. Ma'am, Portia. Okay. Lambo's like, you should let me love you. Okay. I think that he wants to provide every bit of opportunity because at the end of the day, this woman is prime for some sort of appeal, some sort of ineffective assistance of counsel. I think he knows that they are putting on a show, the people, her attorneys, and they are presenting a little not on par, you know what I'm saying, at least with the folk that they're against in Orlando. And he's trying to be super patient and allow them some leeway. Plus they're a little more, I think they've got, I don't want to say more senior, but let's just say they've got more experience. These are some more seasoned folk. Okay. Doesn't mean more better, but it just means they're a little more seasoned. And I think Judge Cranick is trying to give them some space and opportunity because there's lots of things that come up. Well, we didn't know how to do that. And we didn't provide that technology. And they need to get, Mr. J will be like, well, they gave me a hard copy instead of a PDF. And you know what I mean? Like there's just there's a little bit of a tech gap and things of that nature. And I think Cranick is trying to work with them and not have that be any sort of obstacle on appeal. And keep in mind, I think he's the chief justice. He's at least one of the senior judges. I think he might be the chief justice, if I'm not mistaken. And I'm sure he wants to make this appeal proof, or even if it does get to an appeal, that everything is buttoned up. And he did his absolute best to provide her an opportunity to have due process and all of the things. So you know what I mean? Because sometimes mistakes are made and things fall through the gap. This guy is on his toes. He catches everything.
I would not take that deposition, Judge. When she said, I have not had time sufficiently to answer these questions, these diagnoses, these opinions, if this wasn't set for a definitive date that you had already told me it's not going to continue, I would refuse to take that deposition. But under the promises from the state,
What are the legal grounds of your objection? I'm familiar with the background. I'm familiar with the time frame. I'm familiar with all the dates and the depots and the coordination and everything we had to do to get this all teed up before trial. What are the legal grounds of your objection? I understand the backdrop.
I mean, I don't know if there's a legal ground other than we had an agreement as attorneys, as parties, that I would be notified of a change of opinion and I would be allowed to take a second deposition. That's the only thing I know to object to.
Okay.
Because I was not given that opportunity, which was an agreement between the parties.
Response.
Judge, I don't appreciate the implications that they're making. What I would proffer with this witness is, we spoke yesterday. I asked her if she had any change in her opinion about any of the diagnoses. She said no. And I asked, well, then my position, my understanding of her position is that it doesn't matter whether she had PTSD or not, because what Ms. Boone said at the time was that she zipped Mr. Torres up into the suitcase. They were both laughing. And once he was already secured in the suitcase, she became angry and then did all the things that she did. My expected answers from the doctor, based on a very brief conversation yesterday and this morning, was that if I asked her whether or not PTSD or BSS had anything to do with this particular case, that her answer would be, it doesn't matter because of what she stated happened. I'm not asking her about her diagnosis of PTSD. I'm not going to be going into narcissism. I'm not going to go into whether or not she ever delineated the difference between adjustment disorder or anxiety, because my understanding of what she told me was that none of this matters. None of this matters because of what she said to us during the evaluation.
But the question was, and I may have to ask Madam Court Reporter to read it back, but my memory of what the question was is, have you formulated an opinion with regard to PTSD?
And my expected answer was, it doesn't matter because of what she said during the evaluation.
Okay. Unfortunately, that was not the answer that came from the witness. The answer was a
But that's not
definitive no.
the attorney's fault.
I'm not casting blame. I'm just going back over of what was asked and what was said. Okay.
Yes.
Judge, and that's his position, that post-traumatic stress disorder, that doesn't apply in this case, and that he, I'm sure, reflected his opinion to the expert. But that doesn't mean that that's my opinion, that post-traumatic stress does not apply.
That's irrelevant for the purposes of this argument.
Well, their discussions and him feeling like it didn't apply.
Okay. As an officer of the court, he just told me he spoke to the expert yesterday and the opinions hadn't changed. And the opinion that was offered at the deposition was, I'm not sure. And based on what he had proffered as to what he expected the answer to be, the answer was not going to be any different. It's not applicable. It doesn't matter because of what she told me. That's unfortunately not the answer that was given. So what is it that you're asking me to do at this time, Mr. Owens?
I'm asking, I don't know if we need to proffer the entire testimony of this witness, because opinions and diagnoses have apparently changed. I think I have a right to take a second deposition before she testifies.
What other opinions, Mr. J, if any, are going to be offered by Dr. Warner?
Can I just proffer?
Yes.
All right, you've been present for all this hearing, yes, doctor?
Yes.
Am I misrepresenting any of our conversations?
No.
All right. And so if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of the case as the defendant relayed them to you, what would be your answer?
That it's not related to the incident as she reported it.
Okay. And if I ask you, therefore, if there were any prior instances of violence, would that change your opinion? What would your answer be?
No.
And if you reviewed any other materials, would that change your opinion based on what she told you about what happened that evening?
No.
That's it.
Judge, number one, she's given a legal opinion. Number two, it's a discovery violation.
What is the legal opinion?
That post-traumatic stress disorder doesn't apply in this case.
Dr. Harper testified it did, and that's what experts do.
I would like to have known.
Not to mention, and I'm not, no offense to any of my mental health professionals, but one is a medical doctor and one is a PhD, and the medical doctor has as much, if not more, and diverse training than the other. So I feel, you know what I mean? Like, look, come on now.
That, and that was going to be her opinion before today.
That's not a change in testimony. That's-
Where is that a change in the
So you
deposition?
have to read the whole transcript. I asked.
No. This is a 87-page transcript. You're objecting. You have the burden to establish.
The jury was excused maybe 10 minutes ago. Yeah, they Judge Cranick, if you've been watching, is absolutely clutch on not exposing the jury to these extraneous sidebars. But this is the stuff we like, okay? But no, the jury they're having coffee. They're in the jury
Establish your
room somewhere.
objection.
Give me a minute. I'll read through it and find where I asked her.
Look, if you found the smoking gun last night in the deposition, or you found things that were important, sir, highlighters have been around for a long time. Post-it notes have been around for a long time. Flags have been around for a long time, and red pen has been around forever. Why hasn't someone been searching the transcripts and marking up the transcripts with the TT that you were going to need when you got to court? You got those two ladies behind you. Shouldn't they have already, while this is going on, they should have been searching the document for keywords at this moment and pulling it and said, you know what I'm saying? Like, that's what we do. Okay, come on now. Why? Like, they should already be giving him a Post-it note and telling him what page, what line. Hello? Because I guarantee you one of them found it and he didn't.
I mean, this isn't the first time I've looked at this deposition. The state provided it to me when we had the hearing on whether or not battered spouse would be permitted. And the state provided specific highlights for me to look at. At no point in time did the defense say, look at this, look at this, look at this in her deposition when we had that hearing.
I think he also knows that people are going to take the opinions of the more seasoned medical doctor in psychiatry, not to discount the psychologist whatsoever, but her testimony was deemed a little sus yesterday. And if they come through with someone who is even further credentialed, more experienced, all of the things, it might supersede her testimony, and they may take it as, no, this was not PTSD. The story that Sarah told us doesn't involve PTSD. It involves narcissism, because she has an inability for compassion, empathy. Her needs are more relevant than another person's, which is what the defense expert said the other day. And she decided on that day that no matter what, George was in that suitcase and she wanted to give him a piece of her mind, which she videotaped. And then furthermore, she beat the shit out of him while he was in the case. And then she took her ass upstairs and went to sleep. Okay. So PTSD really didn't have anything to do with that, because she had already made a decision and verbalized on numerous occasions that her plan wasn't to kill George. Her plan wasn't for him to suffocate. And when asked what her plan was, she can't articulate the plan, but she talks about a plan, right?
So other than what's being provided to me right now and what's been testified to this morning, I don't know what opinions she has. All I know in coming into today is what the basis of her opinion was, specifically with regard to any of the statements that Ms. Boone had provided, which was the whole crux of the state's motion to prevent battered spouse from coming into evidence.
Judge, if you look at page 66, line 20. Let me know when you're there, Judge.
Hang on. Yes, sir.
Page 66, line 20, question. Okay, so other than the couple of hours that you intend to maybe reflect on your notes and anything else, any other work that you intend to do on this case? Answer 23, no, sir. Not that I'm aware of. Line 24, question. And you've expressed all your opinions, at least generally here today. Answer, page 67, line 1. Yes, sir. Question. Then I go into these. Then on 67, line 7, question. Just double dog sure You admit that you have no other opinions other than the ones you've expressed here today. Line 10, answer, that I've been asked about. If I'm asked something else, that I'll offer it. Number 12, question, and you've been provided all the resources you need to rely on and express your opinions. Line 14, answer, I have based an opinion on the resources that I've been provided. If there's other things out there to be provided that may or may not change my opinion. I believe it's a discovery violation because I should have been notified that there was going to be a change in opinions here today. And we had an agreement that I was going to be allowed to retake the deposition and not be ambushed in the middle of a trial with a new opinion.
What new opinions are different based on what Mr. J proffered the testimony is going to be?
I have to ask Madam Clerk to reread the question and the answer from the expert. It's been so long now.
Madam Clerk, or Madam Court Reporter, are you able to reread the portion of the proffer as to what Mr. J asked of the witness? Absolutely. Of course. Court's going to step off for a moment while Madam Court Reporter is able to provide that reading. Just,
because we have the luxury of time on our side and the medallion is up, let's go ahead and see. We don't have to wait because we've talked through some of our time. So we are reclaiming our time. Shouts out to the good sis Maxine Waters. Okay, Congresswoman. Okay. From LA, baby. Okay. All right, guys. It's second cup time. We are reclaiming some of that precious time. Okay. It might be time for a internet comfort break or get your kettle going and make your second cup, because this might be our one time before lunch, because it's 10:30. They'll normally take around 12:30. And but yeah, they want that PTSD because they want the snapped scenario. Okay, they want she snapped, but because they want the battered woman instruction, because we still have not heard an overt act. They're trying to make from the police interrogation video the suitcase video portion where she says, "This is how you make me feel when you cheat on me," and da 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 da. And I don't know whatever else she said. I'm blanking now on what she said in the video, but this is how it makes me feel. This is how I feel when you cheat on me, and things of that nature, right? So they want to be able to explain that she's suffering from PTSD. So she may have had an irrational reaction to something that would seem innocuous to most people who are of sound mind and body. Ma'am, if she has PTSD, they can use a PTSD, but I still don't think it's going to help with the jury. But they're trying to get PTSD to explain the actions and to make George's 2 fingers through the suitcase the overt act to then bring in the battered woman. It's like they need A to bring in C, because if you have A, then they can factor in B, and then they can also factor in C. But without A, it still don't make no sense. Okay, because you know why? Because it's all a lie, and Sarah made all this up, and they're trying to work with what they have. So anyway, here's Judge Kranick. He's back. Let me let these dogs go for a comfort break.
All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State.
Dave Castro on behalf of the state.
William J. for the state.
Defense.
James Owens, Ms. Boone.
Kevin Beck, Ms. Boone.
Ms. Boone is seated at counsel's table wearing the same clothing from this morning. Madam Court Reporter, have you had the opportunity to review the transcript as to the proffer of Dr. Werner's testimony?
Yes.
Okay, you may proceed.
By Mr. J, question. You've been present for all of this hearing, yes, doctor? Answer, yes. Question, am I misrepresenting any of our conversations? Answer, no. Question, all right, so if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of this case and the defendant relayed them to you, what would be your answer? Question, that it's not related to the incident as she reported it. Question, okay. And if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. Question, if you reviewed any other materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question, all right, that's it.
I don't think that's the very beginning, before I objected.
What was asked was to read back the proffer.
Owens, sit your ass down.
I thought I was asking to go back to the very beginning.
He needs to stop. He's very unprofessional, and he doesn't.
Was asked and her response and my objection to it.
What was specifically asked was to the proffer, because the question before the court was whether the proffered opinions are at odds with what was testified to during the course of the deposition. There's the question that was asked and the answer that was given affirmatively provided an opinion as to PTSD. I think Mr. J admits that. Mr. J has advised the court that's not what he was hoping the answer would be. The answer was supposed to be something different, as identified in the proffer, which is why I had Madam Court Reporter read back the proffer. So the question Mr. Owens posed to you is whether the proffered opinions that Madam Court Reporter just read back to us are different than what was provided in the deposition.
Yes.
How so?
She tended to explain in the proffer some legal reason why it did not apply in her opinion. That was not discussed in any way in the deposition.
Okay, my question is specific as to opinions. Her opinions were as to battered spouse syndrome or post-traumatic stress disorder and their relationship to the case based on the defendant's responses. The answer is not related to the incident as the defendant reported. Those are the opinions as I understand them based on the proffer, as it relates to battered spouse syndrome and post-traumatic stress disorder.
And I think she can probably do that because she is a board certified psychiatrist and forensic psychiatrist. So she has been trained above and beyond her MD, specifically in psychiatry and forensic psychiatry. She is very well credentialed and also has testified as expert previously to be able to give such an opinion. It's not just YouTube Streets opinion. He needs to stop. I'm sorry. I've watched trials before where you have the paralegals or the other lawyers on the team are sitting there searching and passing off post-it notes and information. Why this guy is struggling through paper? He doesn't have a computer in front of him. Why is he not going through? Most of us can if we recall something, right? Most of us can recall like at least what it has to do with and maybe even a couple of key words. If he had a PDF of that transcript right now, he could find it in 2 seconds. He is not he's showing himself to be not current, and that makes you unable to do your job to your potential, because right now you are stuck in a loser argument. You can't produce the evidence. Clearly your team is not helping you, because he should have had a post-it note by now with the actual reference, because aren't y'all sitting up at night going over this information? Somebody should know exactly what he's talking about and be sending him a note and telling him where to find what he's looking for. Just like the other day when they were going through those pictures and he said that there was a kid in a picture, I think Henderson did, and one of the ladies got up and pulled up the example because they didn't know, because they didn't know. Okay? What do you have people, a whole team of people, if you guys are sitting there at an Airbnb, what is the point of having a whole team if nobody is moving this along? Yeah, where is Henderson? He must be in the bathroom. Okay. I don't know where he is, but Beck is sitting at the table right now. You can see Beck right there. Mr. Late. Mr. I'm always late from a break. Okay. Yes. Okay, a lady. We are witnessing another narc tendencies.
Line 13 was the question, but you don't believe that she suffers from post-traumatic stress disorder in your opinion?
He wants to invalidate her opinion. I mean, that's just, yeah, they're at an Airbnb instead of a hotel.
15, the answer is no. I would have to look back through my notes to see if she fully met that criteria. Question 17, can you explain why you don't think she suffers from post-traumatic stress disorder? Line 19, the answer no. I didn't say one way or the other. I would have to look back through my notes for that. Question number 21.
And she's saying she doesn't feel like it was relevant because based on the narrative that she was told to evaluate Sarah on, nothing was giving PTSD as like a knee-jerk, snapped, blacked out type response of someone who, period. She said, we were having fun. I zipped him up in the suitcase and that was it. So maybe she didn't feel like on high level it was even worth talking about, because at the moment it wasn't giving PTSD. It was me being made, in my opinion, a conscious decision made or semi-conscious under the influence of alcohol.
Something that you may in the future give an opinion about after some time reflecting and reviewing your notes. 24, May. 25, okay, and that's something you will let the lawyers know about if that changes. That's on page 47. 1, 2, yes. That's fundamentally, substantially, materially different from what she's testified as it relates to post-traumatic stress as it applies in this case.
In the proffer?
Excuse me?
In the proffer? She's not rendering it unless I missed.
Yeah, I think he is trying. He's reaching number one. Also, he's not in a position to analyze her answer to the degree that he is, because, sir, number one, you're a JD, not an MD, and she is uniquely qualified in her area of expertise to say things. Even if she's saying the same thing differently, she is uniquely qualified to give that opinion based on her credentials and the reason why she's sitting in the box. Like, you can't tell her or say it's wrong for her to say what she's saying. Even if you weren't privy to it beforehand, you were privy to the deposition and could have asked those questions at that time, and also could have ran that through as an objection or a motion for clarification or anything prior to this moment. But we're going to see how this fleshes out.
Misunderstood the
A
proffer.
mess.
She's not rendering an opinion on PTSD and whether or not.
Yeah, he's totally
Ms. Boone suffers from it.
Well, she led me to believe that she was trying to decide whether or not Sarah Boone suffered from post-traumatic stress. Now in the proffer, they're claiming that post-traumatic stress does not apply. I don't know what the initial question was. We haven't had that read back when it was first going.
he heard something. Sarah probably pinched him on his leg and he got up. I object. He doesn't even remember what he was objecting to.
On when a question was asked, and I believe she rendered an opinion. And I, again, like that to be reread back. What the initial question was, what was.
One of his people should be on live right now on their computer in their ear and could have replayed that back by now and slipped him a note with what the question was. Hello? You see what I'm saying? Like, what is wrong with these people? I don't know how old Owens is, but sir, you need to get with the times, because damn it, you either get caught up or you get left behind. Okay. And it's not even that he's too old. There are people his age and older who are very adept at all automation that is available right now. This guy is, I don't know what he's doing. He's unorganized and very
I know I
unprofessional.
objected. I can't even remember it now. But I know I objected because I knew it was inconsistent.
He's
You asked
looking.
to approach. And
Yeah.
then you explained that the question was it was not something that was framed in the deposition. Multiple times I asked you for a legal objection. And it wasn't until right before or right after we sent the jury out that you provided some legal objection. You know, Madam, if you want Madam Court Reporter to go back and read the question that led us to where we are right now and the answer, I'm totally on board with that. I have a memory of what it was, but nothing like.
Before she does that, can I get the first question of the proffer? If BSS or PTSD has any, can you reread that? So
Let's just reread the entire proffer, just so that it's a clear soup to nuts, alpha to the omega, what the proffer was. Madam Court Reporter, if you could be so kind. Yes, ma'am.
By Mr. J, question. You've been present for all of this hearing. Yes, doctor? Answer, yes. Question. Am I misrepresenting any of our conversations? Answer, no. Question. All right. So if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of this case as the defendant relayed them to you, what would be your answer? Answer. That it's not related to the incident as she reported it. Question. Okay. And if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. And question, and if you reviewed any of the materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question? All right, that's it.
And then if she could go back to the initial.
The doctor looks like she wants to fall asleep. Like, how did I get stuck in this mess? Doctor gave that testimony that is being disputed. She can't even finish her sentence. Owens is shooketh. Okay. Let's advance a little bit. Owens is shook. I don't want to go too much. You see his guy behind him. I don't know if he's back there researching. Looks like he's on his computer. He might be researching law and decisions based on situations like this. You see what I'm saying? Like, where are the defense team's paralegals and juniors who are supposed to be on the job passing post-its with information? I don't want to speed up too much because is she getting the transcript ready? Sarah, you should have took that deal.
Oh. Sorry. Pay no attention to me. Go ahead. My understanding is it was the question and the answer right before Mr. Owens asked to approach.
Question, what was your opinion? Answer, my opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
Can you read that for me one more time, please?
The answer.
Both the question and the answer.
Question, what was your opinion? Answer, my opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
May we please have the previous question as well?
And why is that relevant? Why did she not render an opinion about PTSD? Because based on the narrative, in her mind, maybe she wasn't thinking PTSD because the narrative was not indicative of like a PTSD moment in her expertise. So based on the time that she had, she probably didn't go down a PTSD road because it wasn't giving PTSD to her. So for her to formulate a PTSD moment, maybe she wasn't hearing that, so she didn't go down that road because guess what? Sarah said it was a good day. We were having fun. We were playing hide and seek. I zipped him in the suitcase. She gave everybody all the wrong information and still might be, because let's just remember, Sarah lied once. She's lied twice. She's lied numerous times. So keep in mind, everybody is doing a dance and creating a prosecution and defense around lies. Are we seeing the fruit of the harvest of lies? Just think about it for a second. Bad seeds, bad fruit. You can't get the fruit because it's a bunch of lies. Okay? So they're having to go back because guess what? There's no PTA. Sis made a decision. I'm just saying.
Question, and in this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening? Answer, I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change. Question, what was your opinion?
Mr. Owens?
Number one, that question and answer, she gave a differing opinion than what she gave in her deposition, which, subject to the agreement we had, I should have noticed. Number two, with the proffer, it seems that she's going to find that post-traumatic stress disorder did not apply to the facts as related by Sarah Boone. And that is an opinion that I needed to know about. And I asked throughout this deposition and at the very end, some general, if you have any new opinions or anything new that differs from what you said here today, please notify the lawyers or words to that effect. So it's an evidentiary issue.
I'm sorry, but this is the first I'm hearing about PTSD, and I didn't know PTSD was hand in hand with battered spouse syndrome, because we're only finding out that she was going with battered spouse syndrome and self-defense a week or two ago. 3 weeks ago, let's say 3 weeks ago, they entered in the battered spouse as the reason for using self-defense and that this was a deliberate act because for the past 4 years, 5 months, and however many days, it was an accident and it was unintentional. 3-4 weeks ago, it was now intentional. She zipped him up on purpose. She beat him on purpose. She didn't let him out on purpose. All of those things. So this story has been changing. So my bad for not wasting Florida's money again for hiring probably a very expensive doctor to review yet another story because this woman won't stop lying. Hello? Ladies and gentlemen of the jury, I rest my case. Like, period. You know what I'm saying? Like, my God, this is crazy.
Right to be prepared for the trial through discovery to know what the witnesses.
The people need the right to know the actual story.
This is a discovery violation based on two things. One, her initial answer to the question that I objected to, and then two, the proffer is a new opinion. It's a discovery violation. I asked that the witness be stricken.
Any response?
Judge, I think it's clear from my original question that the intent that I stated was the intent of my question to get the answer that I intended to get was what the question was intended to elicit from the witness. As far as the discovery violations and continued attacks, I'm not convinced he understands what the answer means or what it's going to be. The answer isn't going to be Ms. Boone didn't have PTSD, hence, therefore, battered spouse syndrome doesn't apply in this case. Mm-hmm. What I believe she's going to say, and what I believe I've been saying she's going to say, based on our conversations, was irrespective of whether anybody believes Ms. Boone had BSS or PTSD, it is irrelevant because of what Ms. Boone told her happened at the time of the event. That is not a discovery violation. She was specific in saying, if you have any questions you want to ask me, I'll give you an opinion. That is exactly what she said on page 67 of the deposition in response to a question that starts at line 7. Question, just double dog sure, you admit that you have no other opinions other than the ones you've expressed here today. Answer, that I've been asked about. If I'm asked about something else, that I'll offer it. They didn't ask about the interplay of the facts with the relevance of the syndrome. That's them, not the state.
Any other argument?
The totality, if you read that deposition and all that we talked
I
about-
specifically asked you, Mr. Owens, to point out for me
I
what,
pointed out,
excuse me, I specifically asked for you to point out specific portions of the deposition that are at odds with either A, the opinion that was previously given, or B, what was proffered to. You have provided me pages 45, 46 of the deposition relating to specific opinions on whether or not Ms. Boone suffers from post-traumatic stress disorder. Are there any other portions of the depo that you would like to point out for me? I am not going to read an 87-page deposition and continue to waste our jurors' time as we try to find a solution for the situation that is now before us. If there are specific portions of this deposition that are at odds with the opinions that have been proffered and or provided so far, I would ask you to direct my attention to them,
well, the ones that I expressed.
other than what you've already identified.
The ones that I expressed, and that just the understanding that we had, that she, in the pages that I have talked about previously here today, in the pages that I referred to about our agreement, that she was going to let me know if there were any opinions that she had in addition to the opinions that she gave in the transcript.
Okay. All right, thank you. All right. Any other argument, Mr. J? Okay, thank you very much. All right, the court has had the opportunity to listen to the proffer as read back by Madam Court Reporter, the read back of the opinion that was previously offered, the portions of the deposition which have been highlighted by the defense specifically pertain to opinions by the defendant as to whether or not the defendant suffers from post-traumatic stress disorder. That opinion is not being offered. The opinion pertains to the relationship of battered spouse syndrome and or PTSD as it relates to the facts of the case as the defendant has relayed them to you, and that they are not related. However, the deposition is identified by the defense, identifies that if there were any additional opinions, that there would be notification. So the court at this point in time, as there has been an alleged discovery violation in accordance with binding precedent by the 6th District Court of Appeal, which is binding on this trial court in Young v. State, 369, Southern 3rd, 1243. At pinpoint 1248, the court is now going to conduct a discovery violation or discovery Richardson hearing. State any other arguments with regard to the elements of a Richardson hearing?
No, sir.
Okay, thank you. Any other arguments with regard to the elements of a Richardson hearing, Mr. Owens?
No, other than I understood she did give an opinion about post-traumatic stress in that initial series of questions.
Okay. All right, the court, again, reviewing the proffer and the opinion, finds that the state's violation was inadvertent based on the proffer by the state, which was agreed to by Dr. Werner as to the conversation they had last night, as to the opinions and whether or not that they had changed. However, I do find that that violation is substantial with regard to the opinions based on the testimony in Dr. Werner's deposition that any other additional opinions would be notified to the defense. As it relates to the third category, the effect on the defendant to properly prepare for trial. Although the questions in the deposition as highlighted by the defense so far are do not address the opinions being currently offered, I do find that it had some impact on the ability for the defendant to properly prepare for trial. As it relates to the opinion that was previously provided as read back, specifically my opinion was that she did not give enough information to diagnose her with PTSD at the time of the evaluation at the jail. What is your position, if any, with regard to that opinion now that the jury has heard it? Mr. Owens. Because my question is, do you want it struck?
On that issue, we'll address it on cross-examination.
So you do not want it to be struck, and you do not want a curative instruction.
Well, I'm going to question her about post-traumatic stress, so it's going to come out through my cross from the deposition about what she said, and then it's inconsistent with what she said here today, so I'm going to want to rely on that question or that answer.
Okay, all right. Ms. Boone, have you been paying attention to the questions and answers and the readbacks of both the proffered testimony and the opinion testimony?
Yes.
And are you on board with the strategy not to seek to strike that opinion?
Yes.
Thank you.
Don't come back later saying that you didn't agree.
With regard to the
and
proffered testimony, I'm going to permit now in open court, and I will oversee the deposition for you, Mr. Owens, to inquire as to those opinions.
I'm sorry.
With regard to the proffered opinions, the court will oversee a deposition now, and you may proceed.
Right now?
Yes. With regard to the proffered opinions. And I believe that will provide a cure for the discovery violation under the Richardson violation based on your request not to strike the prior opinion. And since you're going to utilize that on cross, I find that the prejudice is limited. But with regard to the new opinions, I will give you the opportunity to depose her now, curing the prejudice at that point in time. You may proceed.
Dr. Warren,
Yes, sir.
good morning.
Mark?
At some point, the state attorney notified you that you were to come today.
Correct.
Did you and the state attorney have a discussion about your testimony?
Yes.
When was that discussion?
Briefly last night.
So y'all talked on the phone last night?
Yes.
Have y'all had any discussions since the phone conversation last night?
Briefly. This morning.
sorry, guys.
And how long was the phone conversation?
Less than 5 minutes.
How long was the face-to-face conversation?
Less than 5 minutes.
Did y'all discuss that your testimony would be that you did not have enough information that you gathered from Sarah Boone to form an opinion as to whether or not she suffered from post-traumatic stress disorder?
Correct, that my opinion hadn't changed.
I'm sorry?
Yes, that my opinion hadn't changed, that I didn't have enough information.
Okay. And did the state attorney speak to you about that it didn't matter whether you had an opinion if you didn't feel like the facts that Sarah Boone had given you as it relates to the facts and issue in this case, that you didn't, if you didn't feel like post-traumatic stress even applied, then you could answer that way?
Correct, that was my opinion, correct.
But did he present that to you initially for you to form an opinion about it?
No, my opinion was that it didn't apply because of the way that she described the incident to me.
Was that your opinion back when I took your deposition?
Yes,
When did you form that opinion?
when she described the incident to me.
Why didn't you let us know that was your opinion at the time that I took your deposition?
You didn't ask me about that, sir.
Do you remember me asking you any other opinions that you may have as it relates to this case?
You didn't ask me specifically about that.
I understand that, but you're saying you formed that opinion.
Look, she ruled it out. Look, based on the narrative, it could be fair to say she ruled out narcolepsy. It's fair to say that she ruled out kleptomania. It's fair to rule out any other medical condition. There are a myriad, an array, a plethora of diagnoses that are out here. And based on what she's hearing, immediately someone with a brain is going to start to hone in. And they're listening, they're hearing, they're ascertaining, they're making a judgment. I'm not going to say, you know what? It's not this. It's not that. It's not that. It's not the kitchen sink. It's not the refrigerator. It's not the driveway. It's not the mall down the street. What the fuck does he expect her to say? You should have gave her a list of 1,000 things to rule out, and she could have checked off the things that apply. And PTSD didn't apply to the situation based on face. So I feel like there's a communication gap of not asked and not able to answer, because they're not asking her the question that, based on the totality or the narrative, you immediately ruled that out, just as if I would have ruled out the common cold. The common cold didn't make you kill George. Your narcissistic tendencies did, because your desire to dominate this man and run him, control him, superseded common sense. And that's why we're here today. Come on now.
Prior to the deposition, correct?
Yes. The state attorney and I discussed that on the way out of the jail, as a matter of fact.
After the deposition?
No, sir. After the evaluation.
Okay.
On the way out of the jail.
All right. And I asked you, were there any other opinions that you may express at trial after you had discussed that with the state attorney prior to the deposition? Is that correct?
Yes.
And so you were aware that I didn't want to be ambushed at trial. I wanted to know any and all opinions that you may be expressing in the Sarah Boone case.
I didn't know what specific information you wanted, sir. That's why you had a deposition. I answered your questions. I don't know what all information you want me to provide to you.
So because I didn't ask you specifics, you felt like you didn't have to respond specifically?
No, sir. I answered all of your questions. And as I said, I'm happy to answer any questions that I'm asked. I don't know what questions you want me to answer.
But you know that this was a central issue in the case. Did you not? Your opinion
Yes.
is relating to a central issue in this case.
Correct.
You're aware Sarah Boone's on trial for murder.
That's
And you had this opinion when I was taking your deposition, and I was asking you specifics about any opinions that you may be expressing in the trial of Sarah Boone, and you did not disclose it.
Well, I told you that I would answer any questions that were asked of me. I have a number of opinions. I know that I don't feel that she's suffering from major depressive disorder. I didn't offer that opinion either. I have a number of opinions.
That's all the questions I have.
Mr. J, anything else?
I'm just making sure you want to inquire,
This is your opportunity, Mr. Owens.
because that was more just about.
Inquire about what?
This is your opportunity to inquire. You are conducting a deposition. This is your opportunity and your only opportunity to cure any prejudice that we've identified with regard to those proffered opinions as it relates to the relationship of battered spouse syndrome and or post-traumatic stress disorder as proffered.
The problem is now, Judge, is I've got my expert, and we weren't aware. You know how in these type cases, the experts are allowed to listen to the testimony of the other experts and read the depositions of the other experts. Dr. Warner, were you given the opportunity to read Dr. Harper's deposition?
I was.
I mean, that's standard operating procedure in these type cases. And now I'm taking a deposition on the fly, and then I haven't had a chance to speak with my expert about those opinions and whether or not that would change her opinion. It just puts me in a very difficult situation, but if I'm ordered to continue the deposition, I will.
That's your decision. It's not an order. I'm just saying that this is the opportunity to cure that Richardson issue. You asked previously to strike the expert. I am disinclined to do that. The case law says that is an extraordinary remedy, one which I am not going to permit.
Dr. Warner, you realize you're in a courtroom.
Yes, sir.
And we're waiting on the jury on the trial of Sarah Boone.
Yes.
Are there any other opinions that you intend to express in this trial that you have not disclosed to me in the deposition or you have not disclosed here today under oath?
I'm happy to answer any questions that I'm asked.
Are you refusing to answer my question about any other opinions that you intend to express here today as it relates to Sarah Boone, who was on trial for murder in the second degree?
Judge, I'm going to object. The catch-all vague question that Mr. Owens wants to ask this expert witness about any and all opinions she may or may not have, 99 out of 100 attorneys would come in here and say that's not how you do depositions with expert witnesses. You have to ask specific questions. Anytime you ask a question like that of an expert, the expert's always going to say, please ask me a specific question. And that's what she did then. That's what she's doing now. It's unfair and vague to ask somebody, tell me every opinion you have.
Judge,
Yes, sir.
we're in the middle of a trial. She's fixing to testify. She's had conversations with the state attorney. She knows what she's going to be asked.
This is the same thing. I wish Mr. J would say, okay, let's say so Ms. Boone has she's suing the medical, she's suing Anthem because she wasn't happy with whatever. And when Miss Broom came into the emergency room, and I'm saying Miss Broom on purpose, Miss Broom came into the ER, and it's my opinion. Did you check for pneumonia? Did you check for gonorrhea? Did you give her a CAT scan on her head? Well, no, because based on what I was proffered by the nurse when they gave me the rundown of the patient that was waiting for me in number 3, I knew I was coming in, and due to my expertise in orthopedics, I didn't bother to check her lungs. I didn't bother to check her head. I'm not a neurologist. I'm not a heart and lung. I'm not any of those things. I came in for a leg. I came in on this. I ruled that out based on the narrative I was given from the intake. From her triage, I made an assessment that we were dealing with orthopedics, okay? I ruled it out. Did I need to go do but she had pneumonia, it didn't go treated? She didn't tell us anything about that. So we didn't treat her for that. We didn't talk about that. And based on what I heard, I didn't see that I needed any additional diagnostics based on we were having a good night. We were having fun. All of those things. It wasn't giving PTSD, so I didn't factor in PTSD. It was giving broken leg. It was given Paige the orthopedist, not Paige the neurologist, Paige the psychiatrist, Paige this one, Paige that one. No, it was giving broken leg. Okay? That's what I'm hearing. And maybe my father was an MD, so maybe I'm just going based on the common sense, very pragmatic approach of you hear something and you are process of eliminating as you are hearing the necessary information. You're doing a sifting, weeding process immediately because that's what they're trained to do. Diagnose, triage, all of those things. She's not going to take you through 20,000 things to figure out what you don't have when she's hearing a very specific situation. So he's very skewed law, and she is a medical doctor. And he's mad because it's not matching up with his forensic psychologist, who all she does is testify. She's built, the lady yesterday, Julie, she has a whole practice around forensic testifying or forensic, being a forensic witness in legal situations. Anyway, let me stop.
asked in forms of opinions that she's going to express. That's why she's here, to help the jury understand the science that relates to the law and express opinions. I mean, for me to ask.
You're asking her about the science as it relates to medicine. She doesn't have to relate to the law. She's a medical doctor. She is relating the science as it makes sense to her. It's your job to understand her. And what she's telling you is it did not apply, therefore I did not factor it in. That is basic algebra. That is basic process of elimination. That is deductive reasoning. That is critical thinking. What this man is being very unreasonable.
We're playing hide the ball here in the middle of a trial.
It's not hide the ball. It's
I
you can't
disagree
find the ball.
That there's any hiding of the ball. There's been a proffer that's been read multiple times as to the scope of the opinions regarding to battered spouse syndrome and post-traumatic stress disorder and its relationship to the facts of the case as the defendant represented them. And the answer is they are not relatable to the incident as relayed by the defendant. That is the opinion that have been proffered.
All right, can I continue with my deposition?
Yes, sir.
Dr. Werner, do you recall expressing that you wanted more time to reflect as to whether or not Sarah Boone suffered from post-traumatic stress disorder?
Yes, that I was going to review my notes to see if I had enough information in there to support or negate that.
All right. What additional information would you need for you to express an opinion that she suffered from post-traumatic stress disorder?
So she did not give me information regarding the presence of intrusive symptoms. She didn't give me information regarding persistent avoidance. She didn't give me information regarding alterations in arousal or reactivity.
Anything else?
No.
Would you agree you failed to ask her those questions?
I asked her if there was any other important information that she felt like she needed to share with me at the end of my evaluation, and she said no.
So a catch-all question.
Correct.
Were there any other personality disorders? Isn't that what you do as a psychiatrist? You diagnose an opinion, express opinions about whether people suffer from personality disorders?
Correct.
Are there any other personality disorders that you have formed opinions about Sarah Boone that you intend to express?
No.
So narcissism, you did not find.
I found narcissistic traits.
In terms of your opinion that she suffers from narcissistic personality disorder.
No, sir, I said narcissistic traits.
Okay. So you don't have an opinion that she suffers from narcissistic personality disorder.
Correct. She displays narcissistic traits.
You expressed an opinion that she suffers from alcohol use syndrome.
Alcohol use disorder.
Alcohol use disorder.
Correct.
Is that still your opinion?
Yes, it is.
Anxiety disorder. Is it your opinion she suffers from the anxiety disorder?
No.
Do you recall in your deposition indicating that you felt like she suffered from either anxiety disorder or adjustment disorder?
That's correct.
And you've changed that opinion now?
I have, I'm leaning towards a adjustment disorder secondary to her legal situation.
Okay. Okay.
So you haven't formed an opinion as to whether or not she suffered.
Adjustment disorder secondary to her legal situation. Sarah is, according to the medical doctor, she's putting on for the city of Orlando. Okay.
Suffers from general anxiety disorder or adjustment disorder.
Correct.
You agree that she suffered from trauma as it relates to the domestic violence history that she expressed to you from the intimate partner violence with George Torres?
Yes, as reported by her. Yes.
Do you have anything to dispute that?
No.
I really think Owens does not understand. And I think he has, I don't know what his history is, but he doesn't understand the complexity of the narc that sits next to him, because her narc is interfacing with his narc, and he's having an issue. It's triggering for him because he's used to Southern gentlemaning his way around, and he's actually having to pull some resources he hasn't had to turn on in a minute. And now he's getting very belligerent, and he's entering into some unprofessional behavior. I think he is too prideful to just say, I'm not understanding. Can you explain to me what I'm missing here? What is the process of getting to that opinion, not diagnosis, that it was not even on the table? Therefore, my example of somebody walks into the ER and their leg is broken. The triage nurse makes a decision of what physician needs to be paged, okay? Or she's going to the attending in the ER, relaying the triage, and they're making a decision based on that of who to bring to the room next. She's triaging in her head. He may not understand her process as a medical doctor versus the paid professional witnesses that he procures to help his clients. He may not really understand her process. It's fair to say, because we don't know what he's been through in the past 30 years. Mr. I've got 30 years of experience. Well, clearly you don't have 30 years of experience in this, okay? That's all I'm saying. She blew his hair back with that last one. I think she's got narcissistic traits. I think that she has adjustment disorder secondary to her legal situation, and that's on
In
per.
your opinion,
Okay.
does she suffer from any form of psychosis?
No.
Is it your opinion that Sarah Boone suffers from acute stress disorder?
No.
Is it your opinion that Sarah Boone suffers from intimate partner violence?
Yes, I think that there is enough history the volatile relationship between the two of them.
Because of that, do you believe that Sarah Boone suffers from battered spouse syndrome?
She may meet the criteria for that.
May. So it's possible? Is that your opinion?
Yes.
Definitively, you can't say?
There's a history of her having that. Yes.
Yeah, but it's not a diagnosis in the DSM, so she really should have said no. There is not a battered BSS diagnosis. It's not.
So you agree she suffers from battered spouse syndrome?
Yeah.
Oh, now it's like, oh, okay. Well, that's my last question.
I believe we've covered anxiety disorder, narcissism, battered spouse syndrome, and alcohol use disorder. Are there any other opinions that you intend to express as it relates to that or any other psychological condition of Sarah Boone?
No.
That's all the questions I have.
Okay. Hello. So he was getting ready to get knocked out the box. So he felt it really wasn't. And he made a mountain out of a molehill and took a 1-hour detour into Mr. J's rebuttal case. Okay. Can you believe it? And I'm sure you guys are going to say, and yes, I can. Okay, let's hear a little bit more. We'll recoup for time in a minute. Girl, a mess, right, guys? Mr. Judge Kranick needs to have he needs to have him.
Any other arguments
He
at this time?
really needs to.
No, Judge, just the one I've already made.
Okay, all right. The court has conducted its Richardson hearing and made its findings. The court, as previously identified, will not strike the expert, as that remedy is quite draconian, and I will not do so based on the questions that were asked as highlighted by the defense and the opinions that were offered. The specific areas for which opinions are being offered were not inquired into, but the deposition did leave it open that I'll ask questions about any other opinions that I'm asked about or anything else that I'm asked during the course of the trial, specifically page 59, 22 through 26 on 1, page 60, lines 11 through 25. So in the abundance of caution, the court has permitted that in-court deposition. Anything else, sir?
No, sir.
State, anything else?
No, sir.
All right, let's go ahead and bring back in our panel and we can.
Before we bring the jury back in, may I approach Mr. Cacciatore on a completely unrelated matter?
Does it need to be on the record or?
Yes, it does.
Okay, go ahead.
We would concede that Detective Copsell and Detective Lowen are not testifying again since they've been here in court this morning.
They're still under defense subpoena.
I
We have
asked,
not,
I asked Mr. Henderson if you guys were calling Detective Capsule again, and he said no.
and we're not, in our defense, our direct defense, is there a possibility that based upon the information the state is going to present today or this afternoon, that we may want to receive or seek rebuttal, and possibly through these witnesses? They're under subpoena, and I'm sorry, Mr. Henderson's not here. I've just noticed her presence. Out of an abundance of caution, I think that we need to clarify for the record that they're here listening to.
What's your base? Well, we're off the record. There's no jury here. That's fine. You all stay where you are. What's the basis for your sir rebuttal?
We don't know because I don't know what the state's going to place in rebuttal. But
It doesn't answer my question. What's the legal basis of a sir rebuttal?
Judicial discretion as to the fairness of the proceeding that the defendant pursued.
Okay. Anything else, Mr. Cacciatore?
No, Your Honor.
Okay. The rule sequestration is still in full force and effect. Detectives Lowen and Capsule, good morning. I'm going to ask you to be excused from our proceedings and not view them and not have any communication amongst yourselves about testimony that has been previously given or any questions that have been asked or answered, and just keep your separate ways as it relates to this case and any questions or testimony that you intend to give, may give, or have give. And then comply with any instructions that were provided to you by the state regarding the rule of sequestration. Thank you very much.
You are excused.
Anything?
So basically, he had Lowen and Copsell kicked out the courtroom. Hello, they are on some bullshit today. Okay.
Anything else, Mr. Owens, we need to address?
Anyone else we need to kick out of the courtroom?
No. Anything else, state?
No, Your Honor.
Are y'all
Let's bring
good
back in
now?
our jury.
After an
And you
hour,
can continue your inquiry, sir.
what's everybody having for lunch? Can you drop it into the comments, please? I would like to know because this is hungry. This has only had coffee, and we probably have a good hour before they break for lunch. Can you believe this? We're gonna make up some time. Look, but let me tell you this. Outside of the doctor being annoyed, right? Let me just say this. Sis has to know she's not stupid. Obviously, ma'am is very smart, I would imagine, right? And what we're seeing. And they had to take a 1 hour. They had to do a 1 hour sidebar, a 1 hour off the record due to her testimony. That's clearly pivotal. So she did her damn thing. She shouldn't be annoyed at all because clearly her statements make a huge difference for this to have occurred. So I don't think she did anything wrong. She did everything right. And it put Matlock and Co. on guard, right? It put them on notice that it's getting ready to it's going down. All right, let me go back to blackened chicken from Publix and spinach. Okay. Okay. Protein shake. Yes. Yes, 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 yes. Okay. It's still morning in Seattle. Yes. And you're fasting. Okay. Quinoa bowl with grilled chicken, avocado, feta, tomato, and cucumbers. Very nice. Nice, nice, nice. Chinese. Okay, fasting till 3. Look at all these healthy people. Look at all of you guys. Look at you. That's why Bougie Gang don't crack, okay? All of this good food and maintenance, taking care of thyself, okay? Eating what's tasty and good for the body. Grilled cheese and tomato soup. Shrimp and Cajun chicken pasta. Yum. Steak tacos. I'll have some. Thank you. Homemade chicken soup. Yes. Oh, with lemon? My favorite. Ooh, a sandwich. A good Sammy. I love a good Sammy. Why do I want to try Nashville hot mozzarella sticks from Chili's? Okay. Because you can. Okay. Chili with cauliflower rice. So healthy. Shouts out to the sis who sent me a Cash App, a little tipperoo in my Cash App. Thank you so much. Appreciate it. All right, I want to advance, but I don't want to miss a word. Garlic Parmesan chicken. I stepped out. Getting some ice cream on my way. I'm going to go to the gym now. Okay. Oh, don't look. Girl, do you enjoy yourself? You know what I'm saying? This is a no as much as we talk, it is a no judgment zone, especially about food, hun.
Yes,
Enjoy
Your Honor. That's to
yourself.
recognize our jury. I thank y'all. You can be seated. Members of the jury, thank you again for your patience. We had some issues I had to address with counsel outside of your presence, and we're going to continue the state's rebuttal case this morning. Again, if you could please just raise your hands to confirm that you complied with the court's instructions during the break. Record reflect all hands have been raised. Mr. J, you may continue your inquiry, sir.
State would move to strike the last response as non-responsive.
Approach.
Come on now. They just came back in and you got something to say. Didn't you just have a whole hour? Okay, I want to reset this so bad, but I don't, and then don't.
Your objection's overruled.
All right. Irrespective of whether anybody has an opinion about whether Ms. Boone was suffering from PTSD or BSS, irrespective of that, based on your evaluation of Ms. Boone and what she relayed to you about the facts of the case, does PTSD or BSS have any relation?
Objection, that's an asked and answered.
Overruled.
No.
And what particular part of her statements about the incident is that?
The whole part where she's describing the part about playing hide and seek and that they were having a good time, they were laughing. When he got in the suitcase, when she found him, they were enjoying themselves. She zipped him up. They were still laughing, having a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent, there was an imminent risk of harm that she needed to protect herself.
Yes.
Okay. If they feel that that's what it was, then you're going to have to admit that Sarah tricked him, as I've been saying for the past 4 days. Sarah tricked him, and all along she knew she was going to trap him and she was going to teach him a lesson, which ultimately resulted in his murder. Like, at the end of, like, you can't have it both ways. Either she snapped or she planned it. Which one? And I can't believe he's that dumb. Doctor needs to relax. Like, she has a lot of experience in all of the things. Sis, take a deep breath. You are on the clock. You're getting paid. It's okay. She's probably not used to someone scrutinizing her to this level, but at the end of the day, boo boo, you're on the clock. You're being well paid, I'm sure. And just don't let that. I mean, she should be on, like, if Sarah Boone's able to keep it together, Dr. Ma'am has to settle down because she's letting him fluster her. And that's not a good look for the jury, because they're going to be like, well, ma'am, like, why does she seem so aggravated? She's letting Owens get on her nerves, and she should have nerves of steel because, ma'am, you're on the clock. I'm just saying, not to say she's not human. You guys, you know what I'm saying? When you're doing something, you got your pearls and your I'm going to the jury box suit on. Keep it cute. Where did the suitcase come from? The back of the closet. I'm not sure what you mean by that. Where'd the suitcase come from? It was upstairs in the closet, and it was downstairs. How it got downstairs, we still have not come up with that. But considering that there was a loud noise, they talked about that on Friday. The loud noise from upstairs coming down the stairs, it's quite possible she threw or kicked it down the stairs. And I also think if you guys, they woke up and she said it would be a good idea to clean the house. I think that she got that house tore up in that rock'em sock'em situation, and ma'am had 12, 13 hours to clean up the house. I don't think they cleaned up the house in the morning. I think she got the house together in the afternoon. The way that the bottles were laid, who lays 2 bottles next to each other in the trash can? The way those bottles were laid, we're giving staged. I think that there was a lot of shit going on, and we don't know the real story. We don't know the story. We really don't know what happened, because Sarah is a liar and she's not going to tell us what happened, because that's part of her narc trait to not tell us. Look at the doctor. I am feeling embarrassment for her. She shouldn't be doing that. She needs to fix her face. That is not a freeze frame. That is not a good look for the jury. Ooh, they're losing their expert at this moment. Girl, she's making me feel uncomfortable. Let me go let these dogs in. You know what? We do have the luxury of time. Oh my God. Did they have to clear the jury out again? Hold on. All right. I'm like, my God. We didn't see anybody stand up. These. They had to probably take the jury out again.
Yes, ma'am.
This question, what is
Just go from, read it from the question, answer, question, objection. Let's just have we can buttress it. Go ahead.
By Mr. J, question, all right. Irrespective of whether anybody has any opinion about whether Ms. Boone is suffering from PTSD or DSS, irrespective of that, based on your evaluation of Ms. Boone, what she relayed to you about the facts of this case, does PTSD or DSS have any relation? Mr. Owens' objection asked and answered. The court overruled. The witness, no. Question, and what particular part of her statements about the incident is that? Answer, the whole part where she's describing the part about playing hide and seek, they were having a good time, they were laughing. When he got into the suitcase, when she found him, they were enjoying themselves. She zipped him, they were still laughing, having a good time. All of that isn't consistent with her having a feeling that she had imminent risk or imminent risk of harm.
Any other argument, Mr. Owens?
That invades the province of the jury. That's a decision whether or not she had imminent risk of harm or perceived an imminent threat is a question for the jury. This expert can express opinions on science, on medicine, but not on the ultimate issue of fact, and explain to the jury that this defense doesn't qualify, that you should rely on me as an expert, and I'm going to make the decision for you, ladies and gentlemen of the jury, by telling you that under the facts expressed to me by Sarah Boone, she was not perceiving an imminent threat at the time.
Response.
It's not an objectionable opinion. It's not an opinion on the ultimate issue. It's an opinion upon the applicability of a particular set of evidence that the test defense has offered, called battered spouse syndrome, to kind of help explain a portion of the use of deadly force or non-deadly force instructions. She's not up there saying Ms. Boone was unjustified in doing what she did. She is not saying that justifiable use of force doesn't apply. What she is saying is, in her opinion, based on the facts that she relies on, given by the defendant herself just a couple of weeks ago, that this particular set of testimony and evidence that has been offered through their expert, Ms. Dr. Harper, doesn't apply. This is no different than one expert coming in and saying, well, yeah, you can know that the defendant was sane at the time, despite his mental illness, because he ran from the police, hid, he concealed evidence, so on and so forth. And therefore, because of those facts, insanity doesn't apply. And a defense expert may come in and say, well, insanity does apply because my client after stabbing her mother to death, called 911, was speaking unintelligibly and singing, and greeted the officers at the door with a pair of knives and wouldn't drop the knives and was incoherent for 12 hours after the offense. Therefore, based on those facts, the expert says, well, insanity does apply. It's not becoming a lawyer, it's not becoming the juror, it is explaining a particular type of expert testimony, and it just happens to disagree with Dr. Harper's. And Dr. Harper came in and said that BSS does apply and that she was in constant fear, and the reason she's in constant fear is because of all the past episodes and whatnot. It's permissible testimony.
Any other argument, Mr. Owens?
That's totally wrong. He claims, the prosecutor claims, Dr. Harper came in and said BSS does apply. That's true. But he just got through saying and trying to get the witness to say BSS, it's not to be regarded. Post-traumatic stress is not to be regarded. It doesn't even come into play. Post-traumatic stress disorder, battered spouse syndrome does not even come into play because at the time she was facing, according to this witness, no imminent risk of harm. Therefore, you can discount everything you hear, ladies and gentlemen of the jury, about battered spouse syndrome.
How does that have anything to do with whether or not it's an improper legal opinion under 90.703?
It is. It's the ultimate issue of fact in this case because self-defense has been alleged by the defense. And the issue for this jury is whether or not Sarah Boone had the right to defend herself with force, deadly force or non-deadly force, based on her beliefs and impressions at the time, whether they were reasonable under the jury instructions, under the special jury instructions that are going to be applied for battered spouse syndrome, under the jury instructions under justifiable use of deadly force, whether her perceptions about the threat was imminent and whether it was appropriate or reasonable to act the way she did. This expert is trying to say that she was not facing imminent risk of harm at the time.
Based on what Sarah told her, what was she supposed to be like? Girl, spoiler alert, you're going to kill your boyfriend. She didn't know that. Only Sarah knew that. Sarah knew she was prime for George to give her one of his Torres situations because she was messing with him the long way and locked him in a suitcase and he's pissed. Only Sarah knew that. And based on what she told everybody else, it wasn't her fault and it was unintentional. And she swore on her kid's life.
Thank you both for your arguments. Court is going to overrule your objection, find that it is not an ultimate issue of fact as addressed by 90.703. The court specifically relies on Dinkins versus State 976 Southern 2nd 660 at pinpoint 661. In that case, a psychologist testifies in the instant case in Dinkins, the psychologist's opinions were not legal conclusions. The psychologist did not opine on the defendant's guilt or innocence. Rather, the psychologist opined only as to whether the victim was, quote, mentally defective, end quote, and capable of consent to intercourse. Although the opinions did go to ultimate issues in the case, Florida law, expressly provides that an expert witness may render such opinion, see section 90.703 Florida statutes, which provides that testimony in the form of an opinion or inference otherwise admissible is not objectionable because it includes an ultimate issue to be decided by the trier of fact. Thus, the jury had the power to accept or reject the opinions and was not bound by such. For those reasons, your objection is overruled.
Madam Court, I'm just going to ask you to read the question and answer, and I have no further questions of the witness.
Okay, thank you.
I'm sorry?
He's going to have Madam Court Reporter read back the question and the answer, and then he is going to have no other questions for this witness.
I object.
Basis.
It was asked and answered.
Overruled. There was a pending objection. I'm allow the state to re-ask it so it's clear based on that objection.
Judge, it's 11:30. I'm going to need at least an hour for my cross-examination.
We're going to begin your cross-examination after we're done with the state advises the jury in open court. There are no more questions. Let's go ahead and bring back in our panel. Excuse me.
Jury's entering.
State, to recognize our jury.
Yes, Your Honor.
Defense, to recognize our jury. All right, you may be seated. Thank you. Members of the jury, again, if you could raise those hands. Juror number 2, back right, he gets it. All right, thank you all very much. Record reflect, all hands have been raised. State, you may proceed.
Request to read back the question and answer.
Madam Court Reporter.
Question by Mr. J. All right, irrespective of whether anybody has any opinion about whether Ms. Boone was suffering from PTSD or BSS, irrespective of that based on your evaluation of Ms. Boone, what she relayed to you about the facts of this case, does PTSD and BSS have any relation? Mr. Owens' objection asked and answered. The court overruled. The witness, no. Question, in what particular part of her statements about the incident is that? Answer, the whole part where she's describing the part of about playing hide and seek, they were having a good time, they were laughing. When he got in the suitcase, when she found him, they were enjoying themselves. She zipped him, they were still laughing, having had a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent risk of harm.
No further questions.
Any cross-examination?
Yeah.
You may proceed, sir.
Dr. Warner, good morning. What all did you consider collaterally as it relates to your opinions you're expressing here today?
I had a number of documents that I reviewed. I'll look at a list. I had the Orange County Sheriff's Office investigation report. I had a transcript of a 2-hour interview of the defendant. I had a.
That's the 2-hour interrogation with Detective Lowen and Detective Copson.
It was an interview, yes.
Excuse me?
Yeah.
Okay, go ahead.
It was labeled an interview. Then I had a transcript of a second interview the next day of Ms. Boone. I had medical records from Aspire Health and Advent Health. And then I had some cell phone records. And I also received the deposition of your expert.
The deposition of Dr. Julie Harper?
Yes.
Okay. And did you listen to Dr. Julie Harper's testimony in this trial of Sarah Boone?
No.
Do you agree you have a right to do that?
Yes.
And did you listen to Sarah Boone's testimony in the trial of this case?
No.
You agree you have a right to do that?
Yes.
And you elected not to listen to her testimony before expressing opinions here today?
Overruled.
I did not have time to do that.
You did not have time to do that?
Correct.
She's on trial for murder.
Yes.
Sustained.
You said you considered some text messages from Sarah Boone's phone.
Correct. I reviewed them. Correct.
Would it be fair to say that of those text messages, they're not necessarily overly relevant?
Objection, may you approach?
Yes.
This is clearly a highly contentious area, and ma'am's word is obviously highly regarded in the sense that Owens really wants specific testimony from her, and Mr. J is not willing to let him get all that. Let's advance a little bit because we have time on our side. We haven't heard a lot of testimony today. Someone mentioned, I think
Who
India.
actually,
We're not hearing as much testimony because it's a lot of law. So yeah, it's one of those different kind of days. Let's try to come back as close to the judge. I think the next long sidebar is going to go right to lunch. It's going to be like, look, he's trying to make a moment for himself, and I think he really is going to come off bad because I just think he's going to come up bad. Where's Henderson today? I have no idea. I would have said, me personally, did you watch Julie's testimony? No. Why did you not watch her testimony? I was preparing for other cases, as also I did not
Objections
want to
overruled.
hear
You may
any
proceed.
information to infiltrate my testimony. Like, okay.
Thank you, Judge. Ma'am, is it fair to say, in your evaluation of Sarah Boone on October the 2nd of 2024, that you felt like the text messages that you received from the state attorney
Objection beyond scope.
Overruled.
are not relevant to your evaluation of Sarah Boone?
Withdraw.
I wasn't sure at the time who actually, I wasn't sure whose phone number it was. In all honesty, we discussed that in the deposition, and I wasn't sure, I have no proof of who actually sent the text, who actually had possession of the phone and put the text, any of the text in.
Well, I was there for the deposition, was I not? Or I appeared by Zoom, did I not?
No, so you were present in person.
Okay, I'm trying to think.
Oh, deposition. You-
The deposition.
By Zoom, yes.
You appear by Zoom, I appear by Zoom, the state attorney appeared by Zoom.
Yes, that's
And we discussed that these were the phone records from Sarah Boone's phone.
yes.
Okay. And at that time, you said they're not necessarily overly relevant to your evaluation. Did you not say that?
I don't recall specifically. I'm happy to look at it.
Can I approach the witness?
You may.
I have it. If you just refer me to the page.
Just a moment.
I do.
Page 14. My question is at line 3. Your answer begins at line 5.
Correct.
And you agree that any,
Let him finish. Let him finish.
well, I'm going on, I'm going to ask another question about the text messages, Judge.
You just said line 5, approach.
A mess.
Dr. Warner, did that refresh your recollection about our discussions about the text messages in your evaluation?
Yes.
And would you agree that they're not necessarily overly relevant to your evaluation of Sarah Boone.
Correct.
And you agree that after reviewing all those text messages, that there was nothing that stuck out to you that caused you to pause and feel like they may have some impact on your evaluations of Sarah Boone.
Permission to go on here.
Can she answer the question?
Have her answer the question first.
I'm not sure what you're referring to in the deposition.
Page 14, my question is at line 21. Your answer is at line 25.
Correct. And I said no. As I said, it made me aware that they had a volatile relationship.
But my question to you specifically is there anything in the text messages that stuck out to you that caused you to pause and feel like that may have some impact on your evaluations?
Correct.
And you agree your answer is no.
As I said, it made me aware. That's not my complete answer.
Okay, well, let's talk. First, you said no.
As I said, it made me aware that they had a
Ma'am,
volatile
ma'am.
relationship. It's not my complete answer.
I know, Dr. Warner, but didn't you say no to me? That was your first sentence was no.
It's not my complete answer.
I understand. I'm going to let you answer that. But when I asked you if there was anything in the text messages that caused you to pause and it would in some way affect the impact on your evaluation, your answer to me was no.
It's not my complete answer.
I understand. But was your answer not to me no?
Yes, but that is not
All
my
right.
complete
Now,
answer.
at the same time, Dr. Warner, at the same time, you expressed that they had a volatile relationship.
That is not the totality of my answer either.
Okay, and I'm going to get to it.
Okay.
But part of your answer was that they had a volatile relationship.
Correct?
And this is in relation to my question about the text messages. You agree?
Yes.
After you said no, you said they had a volatile relationship and that she text messaged calling him an idiot, a fucking idiot for overdrafting her account.
Correct?
And in those text messages, there was some reference to domestic violence between the two.
Correct.
And that demonstrated to you that they had a violent relationship.
Correct.
And do you not agree that that evidence of a volatile relationship had an effect on you expressing your opinion here today that Sarah Boone suffered from battered spouse syndrome?
Judge, you need to object. You need to approach.
I think that the jury is going to, they're highlighting, he's trying to avoid something being said, but what he's doing is highlighting something that's going to imprint on the jury, because this is kind of like, well, damn, what is it that she's saying that he really doesn't want us to hear? So he's being counterproductive. He should have I'm not saying he should have let something ride that shouldn't, but it's really attracting a lot of attention to something that he didn't want to, and it's sitting out like a pimple now. Like, and ma'am is looking frustrated, but he's also trying to discredit or diminish her statements at this time. He's not giving her enough opportunity to express herself, and it's going to make them more curious what she has to say. Excuse, Portia is running around, y'all. Let's see. They will just I think it's obvious that there's something with this the BSS and PTSD, and based on, I mean, he didn't like that answer of secondary to her legal situation. I mean, I'm sorry. I'm not throwing out what Julie said. I'm sure Julie is highly competent as well, but we're judging right now based on this, so it's not even a compare and contrast to me. And I can't even remember her name. Let me hold on a second. Don't tell me. It's in my notes. Based on Dr. Warner's testimony today, I'm taking it on face. Julie had her time yesterday. We heard what she had to say. So I definitely am not saying that Julie's testimony wasn't valid, but keep in mind, Sarah is a master manipulator and she's giving information that she wants either known or not known. And she's spoon feeding the information as she deems necessary to get the result that she wants. And based on the narrative and what she continues to say, but I don't think Owens is wanting to accept that based on what she was given, this is what she came up with. Based on what Julie was given, that's what Julie came up with. Okay, let's advance a little bit because we got time. Okay, here's Judge Cranick looking through his law. Let me try to go back just a little bit.
Jurors, you must not conduct any investigation on your own.
Uh-oh, we missed something. Is he releasing them for
Given
lunch?
you throughout the last couple of days. Give me a moment to.
Her freeze frames are classic. Okay. Sis, I expect better from you. Ma'am, Tonya, don't do that.
All right, members of the jury, it is 11:55. At this point in time, we're going to go ahead and take our lunch break.
I hope Cranick gives Owens a swift kick in his ass at lunchtime. He deserves it. He really does.
I'm going to give you a similar instruction that I've given you throughout the last couple of days. Give me a moment to pull it back up. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors do not watch local news or read local newspapers. Jurors must not have discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again, bless you, that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, we're going to be in recess till 1:30, and we'll pick up at that point in time. Thank you so much for your service. Y'all may be seated. State, anything else?
No, Your Honor, thank you.
Defense? All right, we'll see you at 1:30. Thank you very much. Court's in recess.
I'm trying to figure out what happened. He called them back. So he talked to them. Okay, let's see the shackles. Let's see the shackle moment, and then we're gonna go back a little bit. He objected again.
Like
Hold
that,
on.
that may have some impact on your evaluations.
Correct.
And you agree your answer is no.
As I said, it made me aware. That's not my complete answer.
Okay, well, let's
I
talk,
read my
first you
complete
said no.
As I said, it made me aware that they had a
Ma'am,
volatile
ma'am.
relate. It's not my complete answer.
I know, Dr. Warner, but didn't you say no to me? That was your first sentence was no.
It's not my complete answer.
I understand. I'm gonna let you answer that, but when I asked,
I really think he's making a fool of himself because he's not understanding her process. He should have asked her about her process.
you if there was anything in the text messages that caused you to pause and it would in some way affect the impact on your evaluation, your answer to me was no.
It's not my complete answer.
I understand, but was your answer not to me no?
Yes, but that is not
All
my
right.
complete
Now,
answer.
at the same time, Dr. Warner, at the same time, you expressed that they had a volatile relationship.
That is not the totality of my answer either.
Okay, and I'm going to get to it.
Okay.
But part of your answer was that they had a volatile relationship,
Correct?
and this is in relation to my question about the text messages. You agree?
Yes.
After you said no, you said they had a volatile relationship and that she text messaged calling him an idiot, a fucking idiot for overdrafting her account.
Correct?
And in those text messages, there was some reference to domestic violence between the two.
Correct.
And that demonstrated to you that they had a violent relationship.
Correct.
And do you not agree that that evidence of a volatile relationship had an effect on you expressing your opinion here today that Sarah Boone suffered from battered spouse syndrome?
Judge, you need to object. You need to approach.
And that's where it stopped, right? Ma'am needs to know. Okay. All right, Judge Cranick. Okay, let's get back just a little bit. I just want to get back to. I keep getting to the. Okay. She's still looking like she's about to fall asleep. They're still up there sidebarring.
All right, members of the jury, it is 11:55. At
Okay,
this
so
point in time,
we
we're going to go ahead and take our lunch
there.
break.
I mean, Owens is giving her a defense. That's all I'm going to say. He's giving her a defense. He's giving a vigorous defense. He got his ass up and left. Do you see that? I don't think he even spoke to Sarah. He's pissed. He might have low blood sugar. I don't know. Sir is not happy camper. And he's giving very much attitudinal. The other lady isn't there. I don't know. I know I've said it a couple times. Look, do you see how he just got up and left? Look. Not that he has to say anything to Sarah, but I mean, that is her lawyer. He's pissed. He's out. He's out like a scout on a new route. He's gone. Okay, I'll see you in a bit. I don't know. Okay, Madam Court Reporter is putting on her gloves. She's getting ready to go handle some of that evidence. Secure. There goes Doctor. Did anyone excuse her from the witness stand? I know Madam Clerk doesn't have on like some killer heels. What? Sis got on some heels, okay? Look. Sis got heels on. You see that? Okay. She's like, "Oh no. I work at the courthouse, but I still love my shoes, okay?" Sis is wearing some heels on today. Sarah is getting her shackles put back on, and everybody has a damn attitude. Everyone's blood sugar is low. And I'm going to put up another live. I'll open it up and I'll put on my girl. Sis got her tall clogs on. Okay. You lock everything away. He knows he has bitten off more than he can chew. Yep. Doc is burning rubber from the parking lot. She'll be back. Sarah, it's almost over, sis. Okay. All right, guys. I was trying to find the Baker comment. Damn, did the camera fall? Okay, so somebody dropped the camera. Okay. And just like that, court is just like that, court's over for right now. Just like that, court is over, guys. There is some testimony that the defense does not want in, and I get it because that's their job. That's what they're supposed to do, right? Owens is not giving himself favor with the females, maybe even the males, maybe even the medical professionals. We don't know what this jury is made up of in terms of professionals, what their expertise. But most people can think, most people are able to make a common sense assessment. And it just seems like, but we know more than the jury does. It just seems like I don't think it started from a misunderstanding. I think that Owens does not understand. I think that Owens did not make a determination that there's a sifting process, there's a triage process that medical professionals do. And they're not putting everything on the table. They're actually weeding things out. Their job is to, as someone presents, they are going with what is presenting. They're not fishing for other things and trying to rule out. This is not a diagnostic. This is and maybe it is somewhat of a diagnostic. So let me take that back. But they engage in a little bit more of a sifting out process versus trying to like, does this apply? Does that apply? Type of a process. But he should have taken the opportunity to ask her process and ask her some questions, but he jumped the gun. And I think he's looking like a fool. And I feel like he's trying to make up for a little bit of it. And he's very pissed. Sarah's probably writing all kinds of notes and messages and all kinds of nonsense that is probably frustrating him. I want to say for the 50th time that I love this judge. He's awesome, isn't he? He commands his courtroom. I like the order. I like the order. I like that we get the TT. We get most of the details, and the details that are not for us, we don't get. I mean, would I like to have that? Absolutely. But I think it makes for a more professional and more thoughtful situation. So that's kind of that on that. Anyway, guys, where's my brain? Okay, we got till 1:30, so everybody's got like about an hour break. I'm gonna put up a live in just a second. I didn't do it yet because this whole thing caught me off guard. Also, I mean, I could make it right now, but I'm gonna just do you want me to roll y'all over there? I'm gonna set it up and then I'm just gonna drop y'all the link. Y'all know how to find me. If you don't know how to find me, you just got here by mistake or like, oh shit, let me drop in here. subscribe, set your notifications, and hit the thumbs up. That way, when I go live again, Al will notify you. Who's Al? Algorithm. Okay. The algorithm will bring you back because it's what you want to watch. Okay. For many different reasons. You're here, you liked it, you set your notifications, all of the things, you'll be notified immediately. You cannot diagnose someone with Sarah Boone based on one session or 9. Well, I don't, so good point. I don't even know that. So for the psychiatrist, like she said, she didn't have enough information. Miss Ma'am, who saw her 9 times, didn't ask enough information. We ascertained that yesterday, right? That being said, what they can do is evaluate the situation. On top of that, or furthermore, maybe I should even say, that being said, how can you evaluate a situation that is ever changing from a liar, from an unreliable narrator? It is almost impossible for any of these professionals to adequately do their job, as demonstrated even by forensics. When Owens tried to kind of make someone seem a little incompetent for not running a certain test, or not running this test, or not running that test, why would we? She said that this was an accident. Why would we? We came for someone. We didn't know that this was a homicide until we had a chance to come evaluate the situation, see the cuckoo crazy on deck, and then it was ruled suspicious homicide. And then the person was sent for a autopsy, and it was ruled homicide. Okay? That's why when you call 911, they ask you what's going on. Do you need fire, medic, or police? My boyfriend is dead. Fire, medic, or police. She couldn't say police. She didn't say bring me an ambulance. My boyfriend is dead. My boyfriend is dead. Ma'am, do you need fire, medic, or police? The first question. My boyfriend is dead. She doesn't want to answer the questions from the 911 call. I'm going to go back to 911. Fire, medic, or police? My boyfriend is dead. She is going to shift and move. Like they said, she has adjustment disorder. Let's look that up so we can. She is a classic bob and weave, shift and move adjustment. She makes her adjustment disorder is a depressed mood is a mental condition. We're going to we'll read this one first. A mental condition that can occur after a major life event or stressor, such as death of a loved one, cancer diagnosis. It's characterized by feelings and sadness, hopelessness, tearfulness, as well as a lack of interest in activities that are previously enjoyable. Other symptoms of adjustment disorder: nervous, worry, jitters. So adjustment disorder to me sounds like akin to PTSD. To help manage these symptoms, you can try therapy, benzodiazepine, lorazepam, SSRIs, SNRIs, such as Zoloft. Is it Effexor? Adjustment disorder. Let's see. Adjustment disorder. Let's see. Mental health professionals can find out if you have adjustment disorder by talking to you to identify major life stressors, having emotional behavioral symptoms within the month. Okay. Types of adjustment disorder: with a depressed mood, with anxiety, with mixed anxiety and depressed mood, with disturbed conduct, with disturbed emotional conducts, and unspecified. She had anxiety due to her legal situation, short-term, long-term treatment. Many people with adjustment disorder find treatment helpful. They often need brief treatment, including those with persistent adjustment disorders. Ongoing stress may benefit from longer treatment. It sounds like adjustment disorder may be a little bit of akin to PTSD because it's maybe some sort of like a coping strategy, but not necessarily as severe as PTSD, where maybe there's triggers involved. It's just maybe accommodating your behavior around behaviors or events happening around you, and you are able to let's see, stay tips for to help you make yourself more resilient. Okay, let me find something else. Okay, so adjustment disorders. You have to do some research on this, but I'm trying to understand because I did not become familiar with this type of disorder until the last couple of days. Feeling sad, hopelessness, crying often, worrying, having trouble sleeping, not eating enough, having difficulty. Well, she's an alcoholic too. Ma'am has issues, but her issues have been exacerbated again by her legal situation, probably from the murder of her boyfriend. Also, a plan gone wrong. It's activating her narc tendencies and ways. Anyway, we'll talk about it more. Again, all very interesting, all very good stuff. We gonna let this day unfold. Mr. J, I hope he just doesn't have any to-dos during lunchtime and can have a nice quiet lunch, decompress for the next hour, and come back. I mean, not to say he's not on his A game, but I'm just gonna say it, back on his A game, because Owens is behaving very trollish, and he is just, his defense is a discredit, dismantle, disrupt. Okay. That's Operation Owens. The defense is discredit, dismantle, disrupt. That's my assessment on day 5. They're going with the troll. Okay. And he's operating like a damn internet troll. That's it. Okay, that's my thoughts for on this morning. Okay. Anyway, I'm gonna set up the live, and if you want me to open it up with some music, I will. But I won't be back for a minute. I'll set up the live in probably about 15 minutes before 1:30. So 1:15, I'll open it up. Okay, but they'll be back from lunch at 1:30. Okay. Okay, guys, this was a fun morning. Okay. I'll see you guys in a little bit.